This is a meeting of the Ada County Planning and Zoning Commissioners. We'll start with a roll call of the commissioners. Commissioner Murphy.
Here.
Commissioner Birch.
Here.
Commissioner Colson. Here. Commissioner Rowley.
Here.
And Commissioner Wickstrom. We're going to excuse Chairman Scott and Commissioner Blitman this evening. It'll just be the five of us. Just for tonight, we'll give you an outline of how things will proceed. For this, we have just one application we're reviewing tonight, and how it'll work out is that the planning staff will present a brief overview of the application, and we will be able to have an opportunity to question staff. The applicant will then have 15 minutes to present their proposal and respond to questions from the commissioners. Following that, the applicant and members of the public will have an opportunity to provide testimony, with each speaker allotted 3 minutes. When it's your turn to testify, please come to the podium, state your name and address for the record. Keep your comments focused on the relevant facts of the application under consideration. Public hearings are an opportunity to provide input on land use matters, not to resolve private disputes or personal grievances. Testimony that is disrespectful, hateful, or directed at individuals rather than the application will not be permitted. We also ask that members of the audience refrain from clapping, cheering, or other disruptions, so the hearing may proceed at an orderly and respectful manner. We have just one matter tonight, application 2025-00455-CU-MSP. Icarius Behavioral Health, and we'll turn the time over to Mr. Daniels for his presentation.
Dear Mr. Chairman and Commissioners, project number 2025-00455-CU-MSB is a conditional use and master site plan for a residential care facility for up to 16 adults. The general location of the property is in southwest Boise and is west of 5 Mile Road and north of Columbia Road. The property is located at 11101 West Chapin Avenue. It contains 0.54 acres in the medium-density residential district. The residential care facility will operate out of an existing single-family residence. The residence is 4,197 square feet and has 5 bedrooms. The applicant has installed an approved fire suppression sprinkler system within the structure. The rear and side yards of the residence are enclosed with a 6-foot-tall privacy fence. A residential care facility is an allowed use in the medium-density residential district through a conditional use application. The Ada County zoning ordinance defines a family as a person living alone or 2 or more persons related by blood or marriage, a group of not more than 10 persons who need not be related by blood or marriage living together in a dwelling unit, or 8 or fewer unrelated mentally and or physically handicapped or elderly persons residing in a dwelling who are supervised at the dwelling in connection with their handicap or age-related infirmity, provided that no more than 2 staff members reside in the dwelling at any one time. The Ada County zoning ordinance defines a residential care facility as an establishment that provides permanent provisions for living, sleeping, eating, cooking, and sanitation, and that provides 24-hour non-medical care for more than 8 individuals who need personal care or assistance and supervision. A residential care facility shall include but not be limited to assisted living facility, retirement home, and respite care. The applicant has stated in their detailed letter that the residential care facility will provide short-term, 28 days or less, adult behavioral health residential care programs. The facility will treat community members suffering from non-emergency behavioral health issues such as anxiety, depression, eating disorders, substance abuse, or PTSD and trauma issues. All residential care services will be provided on-site, including living, sleeping, eating, and cooking. Customized clinical and counseling services will also be provided on-site to residents. According to the applicant's detailed letter, the project will be licensed and accredited by the Joint Commission and be a member of Magellan of Idaho. Staffing of the facility will include 24/7 awake staff observation from trained behavioral health technicians. Licensed mental health care providers will work with clients to prepare customized care plans, and counselors will also provide daily individual and group counseling sessions. The residents of the facility are only allowed in the backyard and are required to be under staff supervision. The applicant has made a reasonable accommodation request to A County to provide housing for individuals protected by the Federal Fair Housing Act. Under the Federal Fair Housing Act, persons who desire to live in a group home because it will relieve the hardships that come from having said disabilities cannot be denied housing for discriminatory purposes. Under the Federal Fair Housing Act, group home does not have a specific legal meaning, but has generally been defined as a household where two or more persons with disabilities choose to live together as a matter of association and who may not be subjected to requirements or conditions that are not imposed on households consisting of persons without disabilities. A residential care facility is also considered a group home by the above definition. The specific accommodation being requested is the approval of the conditional use permit. The residents of the proposed facility are disabled and are protected under the Federal Fair Housing Act. The Federal Fair Housing Act prohibits housing discrimination due to a person's disability or handicap. It should be noted that the Federal Fair Housing Act mandates reasonable accommodations be made in the implementation of local zoning ordinances to provide housing for protected individuals. The applicant has requested an alternative landscape plan. An alternative landscape plan can be approved when the following findings can be made. 1, the overall design as proposed by the applicant meets or exceeds the intent and requirements of this article. 2, the existing conditions on or adjacent to the site, including but not limited to differences in elevation, existing vegetation, or the location of existing structures or utilities, would render application of the requirements of this article ineffective. And 3, the overall design shall not be detrimental to the public health, safety, and welfare. Staff finds, as evidenced by photos of the property, that the current landscaping on the property meets the intent of Article 8-4F of the A County Code, as the backyard of the property is fully enclosed with a 6-foot-tall privacy fence. The south property line retains a large hedge of coniferous trees that provides a privacy screen between it and the property to the south. In addition, trees have been planted on the east and west sides of the property, and these trees at maturity will provide shade for the structure. The applicant has stated in their request for an alternative landscape plan that there are conditions on the site that render application of the requirements of Article 8-4F ineffective due to the location of the property in a residential community, the existing vegetation, and the fact that the property is already developed and proposed to be a residence. The existing landscaping blends in with the surrounding residential neighborhood. If additional landscaping screening elements such as a row of trees or a berm were to be placed along the front property line, it would detract from the residential nature of the property. Staff finds that the current overall design of the existing landscaping is not detrimental to the public health, safety, or welfare, as the clear vision triangle at the intersection of West Chapin Avenue and South Carson Street and the property's driveway are preserved. Therefore, staff is in support of the applicant's request for an alternative landscape and screening plan. This application was originally scheduled to be heard by the Planning and Zoning Commission last spring. However, the application had been tabled to provide the applicant time to work with the Central District Health Department for septic permitting and design. The applicant's engineer is proposing an incinerator system, which is a non-discharging system approved by the Idaho Department of Environmental Quality. The Central District Health Department stated in Exhibit 90 that the only septic system allowed for this use is a whole house incinerator system, and a permit must be obtained, system installed, inspected, and approved before an increase in occupancy. The applicant's engineer has provided details regarding the system in Exhibit number 98. The new system will consist of a 2,200-gallon septic tank, a pump chamber, and 4 Septic John WC64 units, which are wastewater incinerators. The incinerators are powered by natural gas. The system burns all liquids and turns the very small amount of true solids to ash. The applicant's engineer has stated that the system will produce very little sound and no odor is emitted from the incinerator. This application has received significant attention from the public. Several individuals do not want the project located in their neighborhood. They have also mentioned to staff that they feel the communication between the applicant and them has been inconsistent. The consensus of many of the comments is that a facility like this should not be located in a residential neighborhood and should be closer to other similar facilities. Several concerns were raised in the written public comments. A brief summary of these concerns are as follows. The facility will adversely impact neighborhood safety and character, property values, noise, lights, and traffic. Some have questioned if the existing individual septic system on the property could handle 16 residents. There are questions regarding the discharge protocol of residents from the facility and where they will go when they leave the facility. There are questions about the check-in and discharge time policies along with security of the facility. There is a concern that the facility will lead to an increase in police and EMS service calls to the property. One neighbor wants a detailed emergency response plan to be included in the conditional use permit. Other neighbors have expressed concerns regarding the distance to EMS and fire stations and longer response times to the property. There are concerns about the business practices of the operator of the facility and how the facility will be managed. Some feel that the applicant has been inconsistent between what they've stated in their application and what has been posted on their website. They want a mechanism outlined in the conditional use permit for neighborhood feedback and reporting issues. There is the opinion that treatment of behavioral health issues is medical care, which they believe to be in opposition to the definition of a residential care facility, and instead they feel that the facility should be classified as a drug and alcohol treatment facility. There is a concern about the severity of the disorders being treated. There is the opinion that the CCNRs do not allow for this type of facility in the subdivision. There are school bus stops in close proximity to the property and safety of children walking to and from school bus stops. There is a question of overcrowding of the residents' personal space, as there could be 4 people to a bedroom and as little as 54 square feet per occupant. Some of the concerns raised by the public are able to be addressed. The facility will likely not create undue adverse impacts on surrounding properties, as the property will still resemble a typical suburban residential property, and the backyard is fully fenced with a 6-foot-tall wooden solid privacy fence and a mature tree buffer along the south property line. The exterior lighting on the home is similar to exterior lighting on neighboring properties. Any lighting on the site is required to comply with the lighting regulations in Article 8-4H of the A County Code. As a term of approval, the facility is required to comply with the A County Noise Ordinance. There is a condition of approval that resident discharges shall comply with all federal and state regulations, and that transportation for residents shall be arranged provided by the facility. The facility will also need to comply with all federal, state, and local regulations. Several agencies have provided comments on this application. The agency comments do not raise any concerns. A couple of key agency responses are as follows. The Boise Fire Department, on behalf of the Winnie Fire District, replied that they can approve the application with the expectation that all applicable code requirements shall be complied with. The A County Highway District responded they have no site-specific conditions of approval for this application, as they do not consider this to be a change of use. The Central District Health Department stated that the only septic system allowed for this use is a whole house incinerary system. A permit must be obtained, system installed, and inspected and approved before an increase in occupancy. Staff finds that this application complies with the A County Code and recommends approval to the Commission, and I'll stand for any questions.
Thank you, Mr. Danderson. Any questions for staff from the commissioners? Commissioner Birch.
Mr. Danielson, it seems to me that the type of individuals that could be at this facility is a very broad spectrum. And so I just kind of want to explore that a little bit in connection with some of the comments that were received written and at the last meeting where this was discussed. So I understand that if you had a veteran that had post-traumatic stress disorder and couldn't hold down a job, that would be somebody that would be completely acceptable at this facility. What if you had a schizophrenic that was convicted of child molestation and is out on parole? They have a behavioral disorder. Wouldn't they be allowed to be here too?
Mr. Chairman, Commissioner Birch, it may be good to maybe have the applicant answer that question. I know in their detail letter, the applicant did mention in the detail letter that, they will not be housing people with severe disorders. So the applicant may be a little, I'm not a mental health professional, so the applicant probably could provide a little bit more insight in terms of the type of residents that would be there and what residents, what disorders, that they would not be treating on the site.
So I guess a follow-up to that is we may be looking to staff just to answer the question of to what degree can this body restrict the type of individuals? For example, could we say you could not have anybody there that has been convicted of any violent crime or child abuse or sexual crime? Would we have the ability to say, if they've ever been convicted of that, if they've ever been arrested for that, you cannot have them at this facility? Do you know, or is that a question for council to determine whether or not that would be within our power?
I would say it probably would be a question for council to determine if that's within your power. I know with the Federal Housing Act, kind of the big summary of it is, you obviously, if somebody is a member of a protected class or has a disability, you can't discriminate against them. So they need to have the right and opportunity to live just like anybody else would. So that probably would be more of a council question, getting in more of those details or specifics.
Okay, thanks, Mr. Danielson.
Yeah, Christian Murphy?
Thank you, Mr. Chair. Hello, Mr. Danielson. So on the application, it says 16 adults. That's typically higher number of occupancy than typical for this particular R6 zone. And I also question state law when it talks about this kind of facility, kind of caps it at 8 for this type of situation. What am I missing?
So Mr. Chairman, Commissioner Murphy, as you kind of alluded to, we have the definition of family. So the county's definition of family in the zoning ordinance is what state statute is, and I think it's also federal statute as well. And so basically, there's 3 definitions of family. So the first definition is, a person just living alone, or 2 people, or more persons related by blood marriage. So if you have you can, I think family can vary. So I mean, if you had a big family that had somebody that had 12 kids, they could have 14 people in their house if they have a very large family. And then if you have people that are not related by blood or marriage, then the maximum you can have is 10. And then if it's a more of a care situation, then it's 8 or fewer unrelated mentally and or physically handicapped or elderly persons plus 2 staff members. And that would be the definition of family, and somebody by right could live in a house without any regulations if they met one of those 3 definitions for family.
But this doesn't fall under family.
It doesn't, because they are wanting to have 16 people, and so that's why they're applying for the conditional use. So for them to have more than 8 people, they have to apply for a conditional use application for the residential care facility.
Thank you, sir.
Commissioner Rowley?
Yeah, Mr. Danielson, couple questions. Just to clarify, the facility in question is in operation, correct?
Mr. Chairman, Commissioner Rowley, it is operating currently under the definition of family. So they have up to 8 people plus 2 staff members. So I don't know how many people they have right now, but it's under 8 people, and they have 2 staff members. So they can do that out as a principal permitted use outright.
Okay.
And that's what they've been operating like that, I think, for probably 3 or 4 months now,
Oh, relatively short amount of time.
as under the definition of family.
Okay, and they're properly licensed or whatever authority has jurisdiction over that type of business to operate as they presently are?
I believe so, yes.
Okay. Changing subjects, regarding the landscaping, there was quite a bit of write-up on that, and specifically them requesting an alternate landscape plan. But am I correct in interpreting that they really just don't want to submit a landscape plan because they've already landscaped it in accordance with the neighborhood standards, and they just want to leave that as is?
So, Mr. Chairman, Commissioner Rowley, our landscape standards typically, the way the landscape code is written is written more for like a commercial, like a strip mall type business is really what the standards relate to. So basically, with our landscaping code, if you have an application that requires a master site plan, they're required to do a landscape plan. And with the landscape plan, they have to meet a certain like 0.12 landscaping. And so the issue is if we were to require them to go fully with the landscape plan, what would have to happen is typically, if you have like a commercial strip mall business, you have landscaping along the street to screen the business. So what would happen in this situation is we would then basically have like a fence, or we'd have basically a screen of landscaping along Chapin Boulevard here. And so it almost kind of further draw your attention to the facility itself, because then you have this, landscaping that doesn't quite, fit in with with the landscaping that you see in the neighborhood itself.
Sure. Okay, last question. With regards to the comment about CC&Rs and not meeting or satisfying the CC&Rs, two-part question. Are CC&Rs actually in effect in this neighborhood? And if so, would they trump the decision of this board?
Mr. Chairman, Commissioner Rowley, there are CC&Rs for this subdivision. I'm not 100% sure if they're in effect or not. The issues with CC&Rs is that the county doesn't enforce kind of private contracts. So the issue that you have is, there could be, a subdivision could have, and there are CC&Rs, things that are against the law. So I don't know if you ever, in the 1940s, there were racial restrictions, things like that, that were in CC&Rs. And so the county by nature doesn't enforce things that we didn't approve. So there could be something in a CC&R that could be discriminatory. And as a county, we don't enforce CC&Rs because we're not going to enforce something that would be against the law, that would be discriminatory. And so essentially with CC&Rs, if there is something that, is in the CC&Rs that would prohibit something that the zoning ordinance would allow, it's really up to the people in the HOA that are under those CC&Rs to do, kind of have work it out civilly, through the court system with the applicant. So it's something that, if the CC&Rs say this isn't allowed, then it's up to the neighbors of those that are under the CC&Rs to take the applicant to court and say, you're going against the CC&Rs. It's not up to the county to do that.
Okay, thank you.
Any other questions? I have two questions possibly. Put your lawyer cap on. So under the Ada County Code, it just limits a residential care facility to 5 basic functions: living, sleeping, eating, cooking, and sanitation. And then what you're showing in the federal law wants to be, it's a little more generous. So which one should take precedent?
I would say the federal law probably trumps that, and we would have to go by the federal statute.
Great. Thank you. Any other questions? All right. With that, we'd like to invite the applicant forward. Please state your name and address for the record, and you'll have 15 minutes for your presentation.
All right. Thank you, Mr. Chair and Commissioners. My name is Jeff Bauer. My address is 601 West Bannock in Boise. I'm a land use attorney at Givens Pursley, and I'm here tonight on behalf of the applicant, Icarus Behavioral Health. We are seeking approval of a conditional use permit for a residential care facility tonight. We will be treating residents on a short-term basis with behavioral conditions in a single-family residential setting. The residents staying at this home are protected by the Federal Fair Housing Act, and we have made a reasonable accommodation request to the county, and that request is to grant this CUP. We have reviewed the staff report and all of the conditions of approval. We agree with staff's analysis of the CUP here, that all of the approval criteria are met, and we are also in agreement with all of staff's recommended conditions of approval. Some of this will be a bit repetitive of Mr. Danielson's presentation, but kind of sets the stage. So the property at issue here is in the south end of town, just outside of the city limits in the Boise area of impact. The corner of Chapin and Carson is where this property is located, on the southeast corner. Those are both public roads. Access to the property, the driveway does take access from Chapin, which is classified by ACHD as a collector roadway. The property is 0.54 acres in size, and it is zoned R6. There is an existing 4,197 square foot house on this property, quite large, together with a 3+ car garage, that's another 1,000 square feet. The home was fully remodeled in 2004. Landscaping was installed, Commissioner Rowley, as part of that remodel that didn't need any approvals. My client purchased the property after that was completed. And so yes, the request for a deviation in this instance is just not to have to rip out what was installed recently. The property does have a fully fenced backyard with mature landscaping. And the water, the property is served by city water from Veolia. So we do have a connection to water, but we are on individual septic at this time. A fire suppression sprinkler system was installed in early 2025 to support the group home use that's currently ongoing under the Federal Fair Housing Act. So the applicant did acquire this property with the specific purpose of providing non-medical behavioral health services to residents in a single-family setting. Icarus is a mental health service provider in multiple states across the West, including multiple facilities in the Boise area. Many of the public comments in the record here are relying on information on Icarus's website related to services provided at other facilities in the Boise area. So to be clear, the group home in this instance at 1101 Chapin will not and does not provide any medical services or alcohol, drug detoxification services. It's all behavioral health service. Prior to purchasing the property, we did due diligence on this project to make sure that the use was allowed in the zone. As Mr. Danielson mentioned, there's two statutes at play here. Both independently allow a group home on this property just as a matter of right, so without this conditional use permit. Those are Idaho Code 676531, that's the state code, and it does follow the Federal Fair Housing Act. It essentially says a group home for up to 8 persons and 2 staff members is an allowed use, and it's also deemed a single-family residential use. And that's important, right, because this is a single-family zone, and so single-family residential uses are allowed as a matter of right. So that has no restrictions. This could be a facility that does treat folks with schizophrenia or drug and alcohol abuse problems. We're not asking for that, but that federal law is very broad and does allow any type of resident. The other statute, or I should say land use code at issue, is the county's own zoning code. It defines family right to include that same use, which is 8 unrelated individuals that need care in a group home and 2 staff members. So with that in mind, we did proceed forward with this project knowing the use was allowed. I think it was Commissioner Rowley, to answer your question, we did start accepting residents to this facility under those matter of right statutes in May of 2025. So real quick, what I'm going to say now is what we're currently doing, and it will be consistent with what we are going to do, even when the number does increase. So the term of stay is short term, 28 days or less. The treatment that people are seeking care for is behavioral mental care, anxiety, depression, substance abuse, not currently detox, but substance abuse in a manner that doesn't allow them to function as a going concern. So that's the same as the Federal Fair Housing Act standard. Also, issues with PTSD and other trauma issues. Resident intake occurs at a separate admin facility in Boise where each resident has a session with a counselor. An individual plan is created for that resident. That resident goes through drug test at that facility. Prior to reaching the facility, they go through a background check. We check them for felonies, other crimes like sex crimes, and we go through that process to make sure that they meet the criteria of admittance. Once they are cleared through the admin facility, they are put in our own transportation and taken to the facility with our transportation. Care is provided 24/7 by awake staff, 3 shifts, kind of morning, swing, and night. There were questions about discharge in the record. So typically the way discharge works is usually 3 to 5 days before the care period is over, that resident will sit down with the counselor and staff and talk about, steps they're going to take once they're out of the residential care facility, make a plan, and then in the next few days when the stay is over, they're put back in the van, taken to the admin facility where they originally started the process, and hopefully they make contact with family or other supportive community there. So again, because the current use of the property as a residential group home is allowed by both state and local zoning regulations, it is a permitted use allowed as a matter of right. So we are here tonight for a CUP, and the sole purpose of that CUP is to provide a residential care facility in order to accept more than 8 residents in need of residential behavioral health care. Facilities like this one are needed in Ada County, where the Department of Health and Welfare has declared there is a mental health provider shortage. Our application specifically requests that up to 16 residents be allowed to reside at the property. We did provide a detailed project narrative that goes through each of your CUP approval criteria, and we believe the record shows that those are satisfied. We've agreed to voluntarily impose many conditions of approval that further ensure the CUP criteria are met. Most of those are captured in the decision that staff has proposed for you. For instance, no resident vehicles are allowed on the property. The only way to and from the property is through formal transportation provided by the operator. Residents aren't permitted in the front yard. They're only permitted in the backyard where it's fenced, and then they need supervision by staff. This isn't in the conditions of approval, Commissioner Birch, but it's something that we will enforce and apply, and we'd be happy to accept a condition. But we are limiting the folks that can otherwise be present in this home. And the limitations include no minors, no convicted sex offenders, no one that's actively chemically dependent, no one with severe medical or cognitive needs, and no one with a history of violent behavior. You mentioned another one that we would be willing to add there is no one on parole. We think that kind of gets caught up in that, but we'd be happy to include that as a condition. I think it is a little bit shaky under the Federal Fair Housing Act for you guys to impose that on us, but as a private operator, we're not taking any federal funding for this facility. We are legally allowed to limit who can attend the facility. Approving the CUP will ensure that these conditions are applied, whereas now there are no conditions on the facility. As the staff report notes, the property is well suited for the use. Just to highlight a few things that we think are key points here, the very large size of the house, the large size of the lot, which is a corner lot. Those 2 public streets create a large buffer, fully fenced backyard, mature trees. And one other thing I think that's important is we do far exceed the standard setbacks in the zone. So the home is centered on the lot. We aren't near any of our setbacks. Staff covered this well, and I think the questions indicate the board certainly understands, but we are well within the definition of a residential care facility. We are not providing medical services here. We are only providing counseling and life skills. So no medical services are provided. One thing not necessarily relevant here, but many of the comments that were provided in the record say, this is more akin to a drug and alcohol treatment facility, which is another use that your code lists. I just want to highlight that that's also allowed in this zone with a CUP and would also carry the same, protection under the Federal Fair Housing Act. So we aren't using that use. It didn't apply to us because we're not strictly providing substance abuse treatment. But if we were, We could apply for a CUP for it, and the Federal Fair Housing Act would require a reasonable accommodation. Staff, again, covered this really well, and we do have our engineer here, Joe Canning from Centurion, if there are any questions about our septic system. But we have come up with a solution with an incinerator system. It's actually an environmental improvement over what's currently there. It's a non-discharging system, which means there is no drain field and there is no leaching into the groundwater of any nitrates. And this is a nitrate protection area. So we are happy with that. Lastly, again, just want to make sure the fair housing stuff is covered well. The folks in this home are protected as individuals with a disability, and therefore they are protected by the Federal Fair Housing Act. And the Federal Fair Housing Act says that failure to grant a reasonable accommodation is discriminatory. And so cities are often presented with this request for a reasonable accommodation. Usually it's for a deviation from a standard. Reduce our setbacks, let us build our building bigger. Ours is actually very minimal, right? We're asking for a permit that's otherwise allowed in the zone. And so we believe that the request for reasonable accommodation is reasonable here. And just to highlight the reasons why, again, the use is conditionally allowed in the R6 zone. So that means you've already made the legislative decision that this use is appropriate for the R6 zone with conditions attached. And I think we've provided conditions that ensure a project that works. Second, it's supported by the operative comprehensive plan. And lastly, we believe it'd be unreasonable to deny the CUP where the approval criteria are met per the staff report and where all of the commenting agencies, particularly fire, have indicated no concerns with the use. And with that, again, we appreciate your time. We really appreciate staff's time. And we're asking for your approval tonight. I'll stand for any questions.
Thank you very much. Any questions from the commissioners for Mr. Bauer?
Mr. Chair, yes.
Commissioner Murphy?
Hello, Mr. Bauer. Can the residents leave at any time?
Chairman Wickstrom, Commissioner Murphy, the question is, can the residents leave at any time? Do you mean the entire treatment program or the facility, like for a walk?
Actually, both.
Both? Yes, it's not, no one is mandating that they be here. It's a voluntary program. If they decide that, 10 days into the stay, they no longer want to be there, they can leave. We would hope that they would leave through our formal, discharge procedure that I described. But again, it's a voluntary program. And our staff is trained to try to ensure that procedure is followed. But yes, people can walk out the door.
Thank you. And then one more follow-up, Mr. Chair. And then you had mentioned that before the intake, they get in a vehicle at your Boise location and then get driven down to this location. And then is it the same rinse and repeat on their way out, or how does that work?
Yeah, Chairman Wickstrom, Commissioner Murphy, that's essentially correct. Admin, I would say check-in at the admin facility, again, consists of an intake procedure where they have a one-on-one meeting with a counselor to develop their plan. Another thing that happens there is all their belongings are essentially searched. Clothes are cleaned to make sure that nothing's coming into the home that would be drugs, alcohol, weapons, et cetera. And then when they are ready to leave the facility after their stay, they are transported back to that same office, where again we hope that their community meets them.
Okay. One more. I'm sorry. Is that okay, sir?
Commissioner Murphy, go right ahead.
Thank you very much. And then if they decide to take a walk and, maybe find some controlled substance that that is causing their behavioral health issue, how does that happen when they come back into the facility if you detect some kind of substance, on them or they're affected by?
Yeah, so Chairman Wickstrom, Councilmember Murphy, I guess I want to clarify my comment, which was maybe a little vague. We are not allowing folks to leave this facility. So if they leave, they've left. They don't come back. Again, with our trained staff, we hope that we would be able to, meet them at the door, de-escalate the situation, bring them back in. But yes, once they're gone, they're gone.
Okay, thank you. Thank you, Mr. Commissioner.
Other questions, commissioners? Commissioner Rowley first.
Got a couple unrelated questions. Regarding the staff, what is the professional qualifications, if you will, of the staff that's overseeing this facility?
So that's a good question. I might need to answer that more carefully in rebuttal. But again, our Icarus Behavioral Health manages behavioral health treatment facilities all over the West. I think they have an internal program, but the 24/7 awake staff, like the people that are there, don't have any specific educational credentials. They're just trained to be essentially mental health service providers.
Trained internally?
Internally, they aren't separate from the staff that's there 24/7. There are licensed clinicians that come daily. That are counselors and other types of mental health professionals.
That don't live there like the staff, okay. Are residents allowed cell phones while they're at the facility?
No, sir.
They are not allowed use of a cell phone?
Yeah, sorry. Chairman Wickstrom, Commissioner Rowley, no cell phones.
Okay. And then lastly, regarding the condition, if you will, for no residents that are, quote, actively chemically dependent. Help me understand what that means. If someone has a drug problem and their friends, their family, even themselves decide, okay, I want to commit, I want to go in this facility and try to clean up my act, so to speak, are they considered actively chemically dependent at that point? And yet you're saying, no, we don't accept those people?
Good question. Chairman Wickstrom, Councilmember Rowley. So one thing that the Fair Housing Act doesn't protect, and I want to quote it here, is it does not protect people with mental impairment that are currently, with mental impairment that have a current illegal use of or addiction to a controlled substance. So that word current is pretty important. So when you're talking about, like, let's say an intervention with someone that's currently addicted and using, they go to a different type of facility. They go to another one of the Boise facilities that does provide detox services and more of a medical setting.
Okay.
What we're looking for at our facility is someone that has gone through detoxification. They're no longer using drugs or alcohol, but they really are struggling not to. And they're having a desire to, and they need the community and the support to not.
Okay. But just to clarify a point you made a couple times, legally, they could accept those types of patients, if you will, right?
Chairman Wickstrom, Councilmember Rowley, that's correct. Under just, without the CUP and the conditions, that's correct.
Okay.
Yeah.
So it's the conditions that would be applied to this conditional use that would prohibit in perpetuity those types of people being residents of this.
That's right. And that is in our, I think it's Exhibit 5, which is our narrative. We listed, the folks that we would not admit. I'm happy to read that, but it's consistent with the list on the screen.
Done. Okay, Commissioner Birch, you had a question?
Yeah, following up on what Commissioner Murphy had asked, I know the residents were concerned that people could come and go. And this isn't a penal facility, I get that, but you've said that there would be staff when the residents would be out in the backyard to kind of watch. That is, I assume, watch to make sure that they don't leave the backyard, correct? So is the facility secured at night? Let's say, for example, that I'm in there and I decide I'm going to open the window and sneak out and then come back. Could they do that?
Chairman Wickstrom, Commissioner Birch, I do not believe, our windows have locks. We have a very good system, security system, cameras. I think staff can see and do monitor. But, no, we don't have bars and locks on windows.
Or alarms that would go off if somebody raised a window?
We do have alarms if windows are raised.
Okay,
Yeah.
thank you.
Other questions? I have just a couple. Thank you, Mr. Bauer. So in the report, it said that there would be doctor visits to manage medications for the residents. So are they stored there, or is the doctor bringing it in? How does that work?
Yeah, Chairman Wickstrom, that is, again, I should have been more detailed in the intake process, but part of the intake process is understanding the medications that the residents may be on. The medications are taken from them by staff at the admin office, and they're locked in. There is an office room in this home where all medicine is kept under lock and key and administered by staff.
So the staff can administer those. It's not required for a doctor to come in and provide those.
No, sir.
Thank you. So under the restrictions, you're limited to 2 staff, but you've got clinicians, therapists, doctors occasionally coming in. So you actually do have a lot of support staff coming in throughout the day, more than just 2 staff members.
Yes,
So
sir.
you're going to have 16 plus more. More people coming in than just those 2 to help run the place. I guess I need to make it more of a question here, but so just pointing that out though, that there is more than just 2 staff there in the facility at a time. The people that are paying for this, it's usually, you're taking private money plus healthcare, Medicare, Medicaid, health insurance companies are helping to pay for these residents that are there.
Chairman Wickstrom, that's correct. Both fully cash and also, yes, the facility does work with Medicare, Medicaid.
Okay. And I didn't bring my glasses, so it's hard for me to see my writing right now. So in the residents in the backyard, they have to have a staff back there. So why, number one, do you have to have somebody go back there with them? Number 2, you could have a situation if you have just those 2 staff members there and everybody else is gone. You go from a 1-to-1 out in the backyard and a 15-to-1 in the house. It doesn't sound like a very safe situation. So why does somebody have to be followed out into the backyard?
Yep, Chairman Wickstrom, that's something that we offered up, again, as a condition to help comfort our neighbors. When people are in the home, I guess it's sort of out of sight, out of mind. It is just a typical residential use. But if we do have people in the backyard, we heard a lot of comments at our neighborhood meeting of concerns with, people in the yard across the fence. So that was our way of trying to address those concerns. And I think, it's a sound policy.
Okay. And last question, if there's nothing else. So a lot of it is with the residential care facility is not under our code, county code, is that it's not in non-medical services are not provided, or medical services are not provided. Would you say, under your definition, that providing clinical and therapeutic services is also a medical service?
Yeah, Chairman Wickstrom, there are public comments clearly from people that have expertise in this arena. And so with your code, under the residential care definition, there certainly is a modifier, right, that says non-medical. It's undefined. And so I think then we go to the laypersons or the common definition of what non-medical means. And I have those. So I'll go to them. So non-medical is not involving, relating to, used in, or concerned with medical care or the field of medicine. And I think then it's important to look at what medical is. So of, relating to, or concerned with physicians or the practice of medicine. So yes, I stand by my statement that we are not providing medical care and the facility is non-medical. We don't have physicians and we aren't administering medical care.
So under your definition, therapeutic, a psychiatrist would be providing medical
Behavioral.
services. Behavioral, well, they also.
Behavioral health
They also
services.
can provide drugs as well. A psychiatrist can. An MD psychiatrist can provide drugs.
That may be correct, sir. Again, we're not prescribing drugs at this facility. We're administering drugs that have been prescribed.
Thank you very much. Any other questions?
Chairman
Commissioner Murphy?
Wickstrom. Oh, go for it.
Oh, I'm sorry, Commissioner Colson.
Okay, thank you, Chairman. One quick question, is there any visitation, like any family that can come there? Or if there's going to be visitation, do you take them off-site? They got to visit in the Boise, or anyways, I'll let you answer that.
Chairman Wickstrom, Commissioner Colson, no visitation.
Okay, thank you.
Any other? Yes, Commissioner Raleigh.
Yeah, sorry, one more follow-up question. The facility as it stands has been in operation, what did you say, 4 or 5 months?
Chairman Wickstrom, May, June, July, August, 4.5 months.
4.5 months. Has there been, in that time period, any emergency services calls to the residents, police, ambulance, other?
Yeah. Chairman Wickstrom, Commissioner Rowley, the answer is yes. I believe there's been 2 instances where neighbors have called the police. No action was taken by the police in either instance. And I believe those instances related to, 1, some shouting in the fenced backyard, and 2, to an individual that was walking down the street and also indicating that he wanted to leave.
Okay, thank you.
One more question, just, are you, you're not restricted to having just 2 staff members, though, are you? Because of the larger number, you're going from 8 residents, 2 staff, now you're going to 16. Are you, under any provisions, allowed to or able to increase the number of staff at the facility?
Chairman Wickstrom, no. Once we are granted the CUP and we're outside of just the as a matter of right, we could have more staff. And I think
I'm sorry, you can or cannot?
we can.
Okay.
Yeah, I think that to the provision in the Federal Fair Housing Act and in your code about the 2 staff members, I think that's interpreted as like living with the 8. So we don't have folks living there. Yeah.
Okay, thank you. Any other questions? Thank you, Mr. Bauer. We'll call you back up after the public
Thank you.
testimony. At this time, I have a list of people who have signed up to speak. To let you know, just not trying to keep anybody from testifying, if what you're going to say has already been said a couple of times, you can stand up and say agree or opposed and help speed things along. Again, not to keep people from coming up here. If you wish to come up, that's fine. But again, if we hear the same comments, 4 or 5 different objections. And so if those have been made, it would help speed things along. When you come up, please state your name and your address for the record, and you'll have 3 minutes. We'll start with Jennifer Stoy, S-T-O-Y.
Hi,
Hello.
I have a USB drive, the purple one.
Okay. Got it right here, so.
Ready?
You might just pull the microphone down just a
Oh,
little bit for
yeah,
you, okay?
I have that issue. Hi, my name is Jennifer Stoy, and I live at 11187 West Chapin Avenue, which is directly on the other corner from this residence that we're talking about. We've lived there for 27 years. And I had this all planned out, but I'm gonna have to go on the fly a little bit. So on my USB drive, I have a full recording of the neighborhood meeting that was held in February, which has this lady here for sure, and I think this
Could
gentleman.
you please address, oh,
Sorry?
please address us.
Oh, sorry. So they were speaking at the meeting, and what they said at the meeting directly conflicts with their attorney's statements on the drug and alcohol treatment and the medical care that they will be providing. So if you want to listen to that in its entirety, there's a lot of information on there. So we went to the neighborhood meeting, and we have, on July 17th, the Ada County Sheriff's Office was called because There was a disorderly person walking down the street in front of the facility. When I arrived home from work on that day, the sheriff's deputies were inside the house. I didn't see them come out with anybody, and they left a little while later. On July 20th, I was out gardening in my backyard, heard a lot of yelling. We ran out front. There was a gentleman in the front yard, and he was screaming and yelling. We called 911. I videotaped the entire thing. I have that as well to show you. And he was yelling that they wouldn't let him leave, and eventually when the police did show up, 11 minutes response time, the police came, made them give him his belongings, and the police took him to a crisis center. Another significant event is that we're in a very rural area. There's 2 10-acre lots directly across the street, plus we all have half-acre plus lots in that neighborhood. There's a lot of livestock. There's active farming, active ranching. On the 1st of September, they called the Ada County Sheriff Dispatch and filed a complaint that the roosters crowing are keeping their patients awake. So if I could show the video, please, if you could hit the first one that says play me, play this one. And if we could make sure it's loud enough. Wait, turn it. Is there any way to make it louder? Because there's a lot of information that's important that he's saying.
Yeah, could we just finish this up and then?
This video is all I have. I'm finished with.
Medical centers in your neighborhood without your consent, and you don't know what's going on in there. You know, what I want to do is to go home. It's worse than drinking. People oversee this little operation right here seem to not want me to go in peace. They do not want me to go in peace because they do not want to release my possessions to me. I hope this goes everywhere. I hope everyone gets to know that you are subject to having a, medical centers in your neighborhood without your consent, and you don't know what's going on in there. I do. There's medical center in your neighborhood. There are thieves. They're not releasing my things to me.
Thank you. Next would be Will Stowe.
And I also have a PowerPoint presentation on that same USB at the bottom, which should say Will's presentation.
Mr. Chairman?
Yes.
If I may, a question for the first.
Oh, yes, I'm sorry.
Person?
Yes. She disappeared and I did. You have a question for you from Commissioner Rowley.
Can you explain what we were looking at in that video? I'm sorry, the audio, I couldn't understand what was going on.
Yes, Chairman Wickstrom and Commissioner Rowley. So he was out front yelling that he wanted to leave, that he wanted his belongings. He was explaining to us that we don't, that about the neighborhood dealing with this medical facility. So he was very well versed in knowing that there was a conflict going on and saying that it was a medical facility and that they wouldn't give him his meds. And just going on, and it went on for 11 minutes nonstop. And then.
Okay, thank you.
Thank you very much. Please state your name and address.
Yes. Hello, my name is Will Stowe, and I also live at 11187 West Chapin Avenue on the opposite corner, directly across the street from the house at 11101 West Chapin. My car stated on their applicational use permit that they were a residential care facility, and that's what they're seeking to be, as you've heard here several times tonight. But all of their advertising clearly shows that they are a drug and alcohol treatment center. They even state on their public hearing notice signs, the ones posted on the street, that they are seeking a permit to be a residential care facility. So I want to share some evidence directly from their website. Next slide, please. This slide, oh, no, that one, yes. So this is the house that you've already seen. I highlighted where they say this is an Idaho Addiction Treatment Center facility. So they're treating addiction. Go ahead and give me next slide, please. On this slide, we have big, bold writing advertising alcohol and drug rehab. I again highlighted on that slide where they state they provide alcohol and substance abuse treatment. Next slide, please. This is a list of substances and drugs that are treated by ICARS. This is a drop-down list on their website. Each of these substances can and do lead not only to drug crimes, but secondary crimes, such as theft, trespassing, disorderly conduct, that's just to name a few. This facility only has a 6-foot fence. Drugs can absolutely be brought into this facility. Friends can just throw them over the fence. They can get them when they go outside. It happens at these facilities. Next slide, please. This is also on their website stating that they work directly with drug court. I've highlighted where it says what to expect when court-ordered treatment at ICARS, Idaho. Hopes of a brighter future with ICARS Behavioral Health. Next slide, please. This slide is the Ada County definition, not of a residential care facility, but of a drug and alcohol treatment facility. This establishment or a portion thereof provides permanent provisions for living, sleeping, eating, and cooking of these types of people with a drug and or alcohol use problem. Shall be include a detoxification facility, inpatient residential facility, clinic, and outpatient facility as related to drug and alcohol treatment. We as a neighborhood believe this is the definition that this house falls under, not a residential care facility. They are a drug and alcohol treatment center. Can I get next slide, please? This is a revised use table from Ada County Planning and Zoning's website, which their attorney also put up a piece of this. And this shows that instead of putting drug and alcohol treatment center and residential care facilities, you guys have rewrote it so it says continuing care facility. I highlighted over on the right that not only includes drug and alcohol treatment centers, it also includes residential care facilities. And it states on there that a conditional use permit must be obtained for this type of facility to operate in an R6 zoned area. They are operating, it doesn't state a number, whether 1 or 16 or 8. This table says that that they have to have a conditional use permit, and they do not. I would like to finish just one thing if I can.
Go quick.
Okay, thank you. Just to close, we are not saying that this type of treatment is not needed. We're absolutely not saying that. What we are saying, it doesn't belong in a residential neighborhood. We as a neighborhood respectfully request that planning and zoning deny this permit and work directly with Ada County Code Enforcement to issue a cease and desist order at the Chapin address until ICARS can go through a proper process to obtain the necessary conditional use permit to even operate this type of facility in an R6 area.
Thank you.
And with that, I say thank you.
Any questions, commissioners? Commissioner Birch?
Yes. Counsel for the applicant said that notwithstanding what the website states, which you have shown, that they aren't going to do a drug and alcohol treatment center there. For the sake of argument, if they didn't do a drug and alcohol treatment center there, would you still have objections to it?
I would, because even people without drug and alcohol problems, schizophrenia problems, people with, I have experience in this in the past that I've dealt with, where people, even with PTSD, people with, they say no violent felonies. Well, drug crimes maybe aren't violent, or people, but anything that's theft isn't something we want to bring into our neighborhood. Disorderly conduct, trespassing isn't something we want to bring in our neighborhood. People with behavioral problems, they have anger management issues, and that's something we do not want to bring into the neighborhood. And the reason I argue that we say it is a drug and alcohol treatment center is because in the neighborhood meeting, they directly said that they were going to be treating people with drug and alcohol addiction.
Thank you.
Thank you very much.
Thank you.
Daniel Mija, and then Christina Mija is going to be right behind you. State your name and address. You have 3 minutes.
I'm Daniel Meehan. Address is 7368 Hilltop. I'm 6 houses away. I'm glad to be in the state of Idaho where laws are upheld with our public officials and public servants, either elected or appointed. And I'm comforted that our laws will continue to be that way. The term resident is, if I go to a Holiday Inn and check in for 20 days, am I a resident of the state or a resident of the Holiday Inn? I don't think so. The turnover in this facility would bring 250 to 350 troubled individuals in our neighborhood every year. The odds are somebody's going to get hurt. I've got grandchildren that I care about. And I care about the rest of our neighbors. I can sit on my front porch and one day I see 20, 30 neighbors walking by. Parents with children in strollers. Elderly people just trying to get exercise. We're bringing these troubled individuals and an unlicensed, I believe, for-profit, out-of-state company. Doesn't make any sense. You know, here, our communities here, we don't have a lawyer. Lawbreakers need lawyers. I don't know how many lawyers Acaris has and kind of do the math. They're trying to treat other lawbreakers, breaking laws themselves. They're operating this without a permit. They know it. When we went to the community meeting, they said it was a done deal. This is a formality. And we're just doing it. I think they were shocked. There was well over 100 people in that garage. Nobody wanted them there. They knew they were lying. And I just asked that you deny their permit. It's not right. It's our neighborhood. It's not their place to bring trouble, to reduce our security. Not right. Thank you.
Thank you very much. Any questions? Thank you very much. Christina Meehan. And Teresa Bellazzini, you're on deck. Please state your name and address. You have 3 minutes.
Christina Meehan, 7368 Hilltop Way at Boise. And I really didn't come prepared. I don't have any logistics. I don't have any data. I guess you said no personal, but I don't know how to make this so it isn't personal. I heard this attorney say that they could come, the residents could come and they could leave. It's volunteer. At any moment they could leave. And that's scary to know that maybe a very troubled individual is walking by my home with our grandson, or a mom with children are walking by, and somebody may come and pass her. That's scary. It's putting people in a situation that has potential to be very dangerous, and it's in a residential area where families lie. It doesn't make sense. It's nonsensical. It just is nonsensical. I just ask that you please consider the people that live here in the residence, and maybe find a different place. I'm not putting them down for trying to help individuals, but I think there's a proper place for that. I don't think it's this place. That's all I have to say about it.
Thank you very much. Any
Thank you.
questions? Thank you very much.
Appreciate
Larry Belzini?
She doesn't want to speak.
Okay, thank you.
Questions?
Tracy Dunn?
I also just agree with what they also said.
Okay, thank you very much. Vonda Whitsitt? Please state your name and address, and you'll have 3 minutes. Okay, yeah. Well, they can't. It's just with, well, they're already listening here, though. Thank you. Go ahead. Thank you.
Good evening. My name is Vonda Whitsitt, 7483 Carson Street. I do have some slides. Hopefully they come up. I'll start by saying that my family has owned the home to the south side of this property for 45 years. I loved the neighborhood so much that after 12 years serving in the Army, I purchased the home directly across the street from my parents. So my mother lives at 7482 Carson Street, and she's in the audience as well. I'd like to say that we know our neighbors. We talk to our neighbors. With this facility, we're not going to know our neighbors. It's going to be a revolving door of people we do not know. We used to pass pastries and treats between those arborvitaes that you see in those pictures. We won't be passing treats. When we saw this house go up for sale, we were excited. We were going to have trick-or-treaters and people in our neighborhood that we could know. We're not going to know these people. They're protected by HIPAA, so we can't know them. We can hear them. I sit on the front porch with my mom and I can hear the conversations that are taking place in that gazebo that you see in the pictures. They're not appropriate conversations for my mother or my children or my neighbor's children to hear. I've also heard people say that they've been there for more than 30 days, and that's firsthand knowledge because I've heard them say those things. If you can't bring up the slides, I can just go over what was in them. A lot of it is what the attorney had stated. It is from their website that does say that they've told us in their neighborhood meeting, it was a 28-day facility, but when you go to the website, it clearly says that they have 30, 60, and 90-day programs in their inpatient treatment facility that is for substance abuse and mental health. I also had on there the application that called out that they have 9 bedrooms and 3 bathrooms that were on the application, but whenever you look at the documents for Central District Health, those numbers are questionable. They're not the same data. The thing that you would see on that picture, though, is they claim that there's a 6-foot fence. There is not a 6-foot fence. If you go in my mother's backyard, it's a 3-foot fence. It's covered by arborvitaes, but there are places where you can clearly see through my mother's backyard into their yard, which, as we've discussed, there's some safety concerns. And with a nearly 80-year-old mother who lives by herself, I'm not comfortable with a 3-foot fence. Granted, they can leave anytime they want anyway, so whether that 6-foot fence is there or not, that is the reality. We don't feel safe. We are very nervous about it.
Thank you. Any other questions? Thank you very much for coming down. Oh, sorry.
I'm going to ask the same question that I asked before. If they did not have alcohol and drug rehabilitation there, would you still object to it?
I would object to it, and part of that is because I don't know who the gatekeeper is to keep that information. Just like the screening of these patients, who's gatekeeping that? Who's going to hold them accountable to only have 28-day stay, and they're going to be limited to all of these? I would also submit that they will not accept violent offenders, but when do they become a violent offender? When is that person going to hit that breaking point and decide, today's the day, I don't want to be here anymore. Let me see where I can go, because I don't have my cell phone. I can't call anybody to come pick me up. I'm out of here. Let me go to this house right here. Cute little grandma sitting there in her house all by herself.
Thank you.
Thank you very much for your time.
Joe Whitsitt? And Mary Kelly, you're on deck. Please state your name and address, and you'll have 3 minutes.
Joe Whitsitt, 7483 Carson Street. I don't even know how to follow that, but one thing I did notice is what their lawyer was talking about, that they don't have, or they're no longer drug addicts, or they're going to be mental. They also said that they're going to do yoga. They don't do yoga. They throw knives and axes in their backyard, and I've seen it. The language that comes out of there, excuse me, is atrocious. And geez, I was in the Army, and I'm ashamed of what I hear. It's ridiculous, and it's not even quiet. You can hear them from across the street where I live, and it's loud and it's constant. My mother-in-law lives there. Shouldn't have to put up with that. Those arborvitaes don't create a barrier. There are holes in the wall this far. You can see right through. Where I assume they're going to put that incinerator, I can see. This is ridiculous. If they need an incinerator, they got the wrong place. Plain and simple. Hands down, wrong place. Thank you.
Thank you very much. Any questions? Mary Kelly. No, Mary Kelly.
I'm opposed.
Great, thank you very much. Mary Kelly's opposed. Tom Fram? State your name and address, and you'll have 3 minutes.
Tom Frank, 6825 South Santa Cruz. I want to talk about the idea that this is a residential care facility. There are 3 examples given in the slides. That is an assisted living, a retirement home, or respite care. I would note that with all of those, someone expects to be there for a long time. That would be a resident. These people, we are told, and again, they keep moving the ball on us, you get different answers every time. 28 days is what we were initially told. That's like a hotel stay. That is not a resident. They have told us these people can't have a visitor. That is not a resident. These are people who are a constantly rotating set of patients. They are not residents. You keep using that word. I don't think you know what it means. Thank you.
Thank you, Rich. Any questions? Thank you. Elizabeth Franks. And Piston, you're on deck. State your name and address, and you have 3 minutes.
Good evening, gentlemen. My name is Elizabeth Franks. I live at 6825 South Santa Cruz Drive. I'm within about a half a mile of this property, but down the hill a little bit. We've heard a lot about neighbors. We've heard a lot about neighborhoods. This is a rural Idaho neighborhood. We moved here 8 years ago and we found what we wanted. We've got community. We've got neighbors who get out and walk. We talk. You can look out at this room and see our neighborhood, and it's good, solid people who just want to live their lives peacefully. This is not in character for this neighborhood. The lawyer makes a good point. The attorney for Icarus is a smooth talker, and he talks about all the code. Please read the intent. Please look at this room and see all of the people who came here. I don't know if I've got neighbors whispering at me in the back because they were detained by the traffic because of the water main break downtown, and they didn't get a chance to sign up. So I don't know whether you will open that up to give others a chance to speak. Even if you don't, please take a look at the number of people who have shown up tonight. We are in excess of 80 neighbors who came down here to see you. This is not something we normally do, except we did it before in June, and we show up at the house when they have information sessions. We care. Please care as much as we do. And Commissioner Wickstrom, you stated earlier, if we're going to just kind of repeat ourselves, speed things along. I understand the need that none of us want to be here till midnight tonight. I get it. However, the decision that you gentlemen are making is not a quick or a short-term decision. This is a long-term impact on our homes and on our neighborhoods and on our quality of life. Thank you.
Thank you very much. Any questions? Thank you very much. Garrett Piston, and then Riley Piston, you're on deck.
We're just opposed.
I'm opposed.
Okay. For both of you, both Riley and Garrett. It looks like another Piston. First starts with an R.
Ryan?
Is that Ryan? RJ? Please state your name and address.
Ron Piston, 7399 South Valley Heights Drive, approximately 880 feet west of the facility at 11101 Chapin Avenue. Everybody here is aware that Central District Health has denied the original application for the septic system. Not only did Central District Health deny the application, they also concluded that the existing septic system and drain field is not sufficient for the proposed 16-people facility. CDH further stated that it would only approve an existing septic system for 6 people, 5 patients, 1 staff. However, Icarus is currently operating the facility at a number that exceeds the capacity of the existing septic. Planning and zoning allowed the applicant time to come up with an alternative system. They're now proposing an individual incinerator for consideration. Under DEQ technical manual, wastewater incinerators should only be considered as alternatives after all other reasonable options have been explored. CDH has stated that the current septic system is adequate for only a residential facility, not a commercial facility. The commercial facility exceeds the existing septic system. The applicant is only proposing the incinerator option for financial gain and so that they can operate the commercial facility. Regarding the proposed incinerator, the following should be considered prior to planning and zoning issuing a decision. Idaho DEQ has designated Ada County as an air quality maintenance area for carbon monoxide and particulate matter. Treasure Valley has also been designated as an area of concern for ozone and particulate matter. These priorities are identified to protect public health because the current air quality is approaching and or exceeding air quality standards. Daily operation of the proposed incinerator will generate combustion of gases and airborne ash, adding to air quality issues. Ada County Code 580101-557 states that during air quality episodes, the use of burners and incinerators for disposal of any form of solid and liquid waste is prohibited. Idaho DEQ data for 2024 shows that there was 28 days where the air quality index was poor and unhealthy. On average, Ada County experiences 14 to 17 days annually where the air quality index exceeds EPA standards. During those times and those air quality episodes, the applicant would be prohibited by operating the unit under Idaho law. Septic system approval by CDH is required. It has not happened before the facility can operate. CDH also said that they would not consider approval of any proposed septic system until planning and zoning approves the change of use of the property to commercial.
Thank you. We need to catch up because
which has not happened.
Okay. Any other questions? Thank you very much. Just to address your wife's comment or the earlier comment, if you didn't have a chance to sign in, we will have an opportunity for you to come up and speak. There will be a list, but after we get through the people that are on the list right now, you will have an opportunity if you wish to speak. Larry Bevins, Barons?
I'm opposed.
Thank you.
I don't think this facility belongs.
If you're going to speak more than that, you got to come up and give your name and address. You can.
Thank you. I'm opposed.
Okay, thank you. Loretta Barons?
Opposed.
Thank you. You've been doing so well in your handwriting until now. Is it Jan Candace Andrews? You live at 11309 West Valley Heights Circle?
Roger, Andrew, opposed.
Thank you. Shirley, same last name. Thank you. State your name and address, and you have 3 minutes.
Shirley Andrew, I live at 11309 Valley Heights Circle. I just have some questions about some things. So the email from Lori Bradigan to Leon Letson said, the fourth bullet point said, CDH will not issue a septic permit until such time that the county commissioners approve the change of use of this property to commercial. So I didn't know if that meant that, are they changing the zoning to commercial or just that it has to be a commercial business? I wasn't sure what that meant. I also had a question about renewal. So if this does get approved, does it go back up for renewal at any time, or we're just stuck with whatever decision is made? My last point is that I would like to see, if this is approved, that they have a straight driveway into the garages. I would like to see them to put a curve around there that goes out to Carson, because in the past 2 months, 3 people have backed out of that driveway right in front of me. And that there is not a hill there. I'm coming from the west. And so I don't know if those people don't know how to drive, but I would appreciate them being able to just go around and so they're not backing right into me.
Thank you very much. Any questions, commissioners? Thank you.
Thanks.
The last name, I believe it's Sullivan. It's 1124 West Valley Heights.
Opposed.
Thank you. Betty Bermasolo? State your name and address, and you'll have 3 minutes.
My name is Betty Berman Solo. I live at 1970 South Cananero Way. And I'd like to ask the commissioners permission to read the testimony of my daughter-in-law and my son, who are TDY with Idaho Guard. And this is very important to them. So I have their testimony, and I'd like to, it's a 3-minute testimony, and I'd like permission to read that for.
It's your 3 minutes, so.
Yeah. Good evening, Commissioners. My name is Erica Berman Solo. I live at 11202 Valley Heights Circle in Boise. I hold a master's in healthcare administration, a bachelor's in workforce education and training, and have over a decade of experience in healthcare licensing, operations, compliance, and patient safety. I respectfully oppose the conditional use permit for Acaris Behavioral Health at 11101 West Chapin Avenue. Acaris is federally registered as both a substance abuse rehabilitation facility and a psychiatric residential treatment facility, or a PRTF, under their national provider indicator. However, in this application, they describe themselves simply as a residential care facility. This is misleading. PRTFs are meant for individuals under 21 per the Idaho Department of Health and Welfare, but Icarus representatives publicly stated that they will treat adults ages 22 to 45, directly contradicting their federal designation. This mismatch raises serious concerns about licensing integrity, billing compliance, and most importantly, resident safety. They claim their clinical team is available 24/7, but it's unclear whether that's in person or via telehealth. In residential treatment settings, telehealth is not an adequate substitute for immediate hands-on care. It increases dropout rates and relapse risk, particularly in high acuity populations. Their proposal also raises safety concerns for the neighborhood. Adults over 21 cannot be legally restrained unless under court order, and Icarus does not have the authority to enforce that. Saying residents, in quotes, won't leave the backyard without staff, close quotes, has no legal grounding. If a resident leaves in crisis, it becomes a public safety issue, and the facility is not equipped to manage that risk. That property was only approved for 8 residents in March. Now Icarus wants to double that. I'd like the courtesy of finishing
Well,
this.
we've got a lot of people coming up, so if you wouldn't mind.
I appreciate the extra time, Commissioner. I want to say that this is in the wrong place. This is well out of the emergency response time for cardiac arrest, and I have a letter in there that describes that. And I will give you my son's letter, which I think should.
Can you give it to Mr. Danielson over here, and he'll take that from you?
Thank you very much.
Any questions, commissioners? Thank you very much for coming down.
Thank you.
Erica Bermasolo? Oh, that's you. You're Erica.
And Casey is the
Okay.
letter.
All right. Krista Butler?
I oppose.
Thank you.
Thank you.
Robert Butler? Please state your name and address, and you'll have 3 minutes.
Yeah, my name's Robert Butler. I live at 7483 South Hunt Street. I
I've lived there for 24 years, which that makes me a permanent resident of that neighborhood. We moved out there because these are working class people and it's a good neighborhood. I guess my question is, what is this? We don't know. It's a group home. It's listed in some of the CDH documents as being a nursing, a care home. If you go to their site, maybe they're just really bad at marketing, but as Mr. Stoy showed above, it shows the type of treatments that they say they're not going to do associated with the pictures of that site. Group therapies. They may have 8 people, 2 staff, 16 people, 2 staff. Are they participating in group therapies where they're bringing people out in the van? Now we've got 30 people on that site. How does that affect it? Septic-wise, yes, this is a poor fit from just that standpoint. They redacted a lot of their addresses within the report of other facilities they have, but you'll notice they're in Albuquerque in New Mexico, and they asked DEQ to say, hey, these are the actual numbers that we use for water. Well, if you're from Las Vegas or Albuquerque, water's pretty expensive. So you're gonna have fixtures that are more for that market, and it's gonna cost you less. You're gonna use less water. So anyway, commonly out there we have this, we can't get commercial in the right spot, we can't get residential in the right spot. And I know you've heard that a lot. This really does not fit in our neighborhood. It's not a family, maybe by the definitions that they've got, but these aren't a group of people living together like you would think in a normal group home that we traditionally have thought of. They are there for 28 days or longer to get their treatment. Yes, this is important treatment. This is not the right place. We finally have some commercial that was going to be rezoned as residential, I believe, down at the corner of Lake Hazel and 5 Mile. It seems like this needs a little more planning, and it needs to go into an area like that. So anyway, I was glad to see tonight at least some of the things they said in their initial is reflected in their CUP. But again, who enforces that? Who says they're only going to be people with PSTD? Who does that? Anyway, any questions?
Thank you very much. Any questions from the commissioners? Thank you very much for coming down.
Thanks.
Joe, Kamey and Canning?
Yes, Mr. Chair, I'm here with the applicant, so if I need it, I'll wait later in the trouble.
All right, thank you. Craig Logan? And then Matt Holcomb, you're going to be next. Name and address?
Evening, Mr. Chair.
Evening.
Craig Logan, 10869 West Parker Avenue, Boise, Idaho. About 3-4 blocks away from the property in question. 29 years in the military, I was taught to be bold, brief, and be gone. So I'll apply those for you, Mr. Chair and commissioners. No amount of lipstick you put on a pig will make it anything other than a pig. And I get that you are in an uphill battle against the Federal Fair Housing Act. It seems to me that if you follow the rules under the Federal Fair Housing Act, you follow the Idaho Code, and you follow the Ada County Code, I think you're just fine. You provide a conditional use, and you're setting a precedent. I don't necessarily want a treatment facility in the neighborhood that I live in. I've gone through this twice before, both times in Boise. That's why I'm in Ada County and not Boise. They put one in across the street from me on Kootenai, had to sell the place. It's had the same bait and switch that you've heard here tonight. So I would encourage you to pay attention and listen to what you heard tonight, especially from the lawyer, because there were some veiled threats in there. And that was not appreciated, at least by me, because I picked him up. And I know he's probably a very kind-hearted gentleman, and he's working for his clients, and his clients need help. They do. And these people need help. They do. 8 people, that's where they're at now, 2 full-time staff. The staff, there was a run around there. They certified? They qualified? I know they've been trained. What does that mean? Leaves me with a lot of questions. And I said I was going to be brief, but I started getting wound up. And with that, I would stand for any questions, Mr. Chair.
Thank you very much. Any questions from commissioners? Commissioner Murphy?
Is it Mr. Logan?
Yes.
Mr. Logan. Just curious, you said you've been to the previous 2 locations that you've lived at and have had a similar facility, we'll say, put right across the street from you. Is that what you said?
Yes, that's exactly what I said.
The last, your last home location that you left in Kootenai, why did you leave?
Drug and alcohol abuse, sex offenders. And I had 2 small children. So I decided to vote with my feet.
And did you observe something specific, or as far as, erratic behavior from people? I was just curious. Or you knew that these people had those specific issues?
Mr. Chairman, Commissioner Murphy, that's going to take another 6 minutes. Yeah, I observed a lot of things. Sex offenders, they were staking out my young boy. So I built a wrought iron fence.
Okay, I think that's sufficient. That gets to it. Thank you.
Yes, thank you very much.
Thank you very much for coming up. Matt Holcomb?
I agree with everybody, so I oppose.
Okay, thank you. Rusty O'Leary? Please state your name and address, and you'll have 3 minutes.
I'm Rusty O'Leary. I live at 10701 West Chapin Avenue. That's about 2 blocks east of this medical facility. And I'll add that I have approximately 30 years' experience providing treatment services in the field of substance abuse and severe mental health disorders. Icarus and their attorneys have claimed to you and Central District Health that they are only a residential care facility. They are actually providing residential drug and alcohol treatment and are correctly considered to be medical care facilities. The multiple federal agencies, the American Psychiatric Association, even Idaho statute and IDAPA rules identify substance addictions as diseases requiring medical care. The Icarus website, and specifically the press release that they sent out in May identifying the Chapin location, claim that they are meeting their patients' medical needs, that Icarus has a medical team, and they comply with the American Society of Addiction Medicine standards and treatment guidelines. Icarus claims to be accredited by the Joint Commission, which accredits only medical facilities and clinics. As a medical facility, Icarus should not be afforded reasonable accommodation by the Fair Housing Act. The Fair Housing Act does apply to group homes, but not to medical facilities where patients reside temporarily only while receiving treatment. The Fair Housing Act typically does not apply to medical facilities that are accredited. It appears that the planning and zoning staff, Central District Health staff, and the code enforcement staff have all accepted the notion that the Fair Housing Act applies based solely on Icarus's claims. Central District Health initially denied Icarus's application for a permit for the existing septic system. Icarus has now submitted engineer recommendations to install that underground incinerator. Central District Health is willing to permit the proposed system, but indicates that the property must be rezoned as commercial property. It would no longer be zoned R6. The Department of Justice and HUD has stated that a Fair Housing Act reasonable accommodation does not apply if Icarus operations will, quote, fundamentally alter the local government zoning scheme, unquote. If the property is rezoned to commercial, then the incinerator system has to be permitted, has to have permits before it can be installed. Then it must pass testing to meet operational standards. The concern is, what if the property is rezoned to commercial? Just a brief moment. Is rezoned to commercial, and then there are problems or delays or even denial for permits for the incinerator system. Icarus has already been in operation since last May, demonstrating that it will operate even without receiving a conditional use permit and before receiving a permit on the existing septic.
Mr. O'Leary.
Icarus is operating as a medical facility.
Need you to wrap it
If
up.
they're approved, there is no oversight on them.
Thank you. Any
May I
questions?
answer any questions?
Can you give me no question, what is the reference for the one statute where that the Federal Fair Housing Act does not cover residential care facilities? Do you have that with you?
In 2014, the Department of Justice and HUD released a joint statement addressing local ordinances and zoning and how it applies to fair housing. In that, they very clearly said that group homes, they're not defined. But they do say that local ordinances, zoning ordinances, do apply as long as they are pre-existing ordinances and they are non-discriminatory. Then if you look at case law, there's lots of case law out there, case-by-case situations, where courts have ruled that a substance abuse treatment facility is considered to be a medical care facility and not subject to the Fair Housing Act.
Thank you. Thank you very much for clarifying that.
Okay, any other questions?
Thank you very much for coming.
All right, thank you.
Russell O'Leary.
My name is Russ O'Leary. I live at 7350 South Glenridge View Drive in Boise. I am also a behavioral health professional who provides medical services on a daily basis. Behavioral health services are medical services. Icarus will be providing medical services at this facility, and they should be treated as such. I grew up in this neighborhood also. It's a fantastic neighborhood. I was fortunate enough to purchase a home with my wife and children just down the road from my parents where I grew up. It's wonderful. We walk down the roads, we bicycle, we're able to go back and forth visiting relatives and friends and family. This facility is now square in the middle of everything there. The ability to travel back and forth comfortably and safely, to allow my children to roam the neighborhood and go visit their grandparents will be impacted significantly by this facility. I ask that you please deny the use. Thank you.
Thank you. Any questions?
Thank you.
Thank you very much. Drew Burley Berkeley. You live at 7272 South Glen. State your name and address, and you'll have 3 minutes.
Hi, I'm Andrew Borson. I live at 7272 South Glenridge View Drive. To start with, I think reasonable accommodations are covered in the approved use and the limit of 8 people. Capitalistic and business accommodations are what is being asked for here. Many housing authorities and agencies consider 2 people per bedroom as a reasonable benchmark. Yet, they're requesting reasonable accommodations, but not providing them to the people they serve. Again, this request is not for reasonable accommodations, but rather profit. When faced with a hurdle such as septic, they've gone far beyond what anybody would consider as reasonable. By committing to purchasing 4 incinerators in the amount of $100,000, I don't think anybody would consider that reasonable. So I would ask you to consider what reasonable consideration means. In my world and in my neighborhood, it's not 16 people in a residential home. Thank you.
Thank you very much. Any questions? Thank you very much. Jeremy Leonard. No, Jeremy Leonard, okay. Anthony Hilling, you're 7110 South Glenside View.
Oppose.
Thank you. Tanya Starr.
Opposed.
Thank you. Fred Thompson. Thank you. Jeanette Wolf. Larry Wolf. Morgan Wigan. Please state your name and address, and 3 minutes are yours.
Good evening, Chairman, Commissioners. My name is Morgan Lutgen. I live at 11501 West Hidden Valley Rim Road, approximately half a mile from the project in question. I would just like to reiterate a few inconsistencies from the applicant's presentation tonight and just share my personal view. One of the things that has not been brought up tonight is the proximity of this facility to a school, an elementary school, 400 yards just down the hill. We saw a video earlier of someone who was asking to be discharged. We know that we're no less than 4 miles from public transportation. There's a lot of concern about someone who chooses to self-discharge, walking past a school, what kind of things might result from that. It's a big what if, I get that, but it's something to be considered and not lightly. I'd ask you to not be distracted by the word salad that the applicant used. Typically, hopefully, those are all great terms, but typically is not a guarantee. Hopefully is not a guarantee. I also have some questions around the training that the staff receives for patients who do want to discharge. My dog is trained, but what are they doing to make sure that the neighborhood remains safe? In terms of, are they going to notify the neighbors? How would they do so? The inconsistencies that I spoke to earlier, just really briefly, licensed clinicians, I think to most people that is a medical facility. They did say also they would be administering medicine from a locked room. There is medicine in the facility. You have to kind of take that into consideration. The applicant self-declared these in the presentation. So I would like to donate the rest of my 1 minute and 15 seconds to Ms. Berman Solo to finish that testimony as well.
It's your time, so she can sign up later and come and speak. So how about?
Thank you for your time.
We'll
Any
give her a
questions?
separate time. Any questions? Thank you very much. We'll tell you, we'll have her, yeah, I thought she was kind of up, sorry. Matt Ludogon?
Opposed.
Thank you. Sherry Glenn?
Oppose.
Thank you. John Glenn?
Opposed.
Thank you.
For every reason that all.
Thank you. Jennifer Sexton?
Opposed.
Thank you. Is it Lorraine Walls? Lorraine Walls?
Opposed.
Thank you. Maureen O'Leary? Please state your name and address and 3 minutes.
Maureen O'Leary. I live at 10701 Chapin Avenue, a couple blocks down the street. You heard my husband and my son speak earlier. I have 30 years experience as a licensed clinician working in substance abuse and mental health in the prisons and within the community. And I just have one question for you to think about. When does a person become violent? That fast. There is no predicting. There is no saying, oh, none of our patients will become violent. We don't let those people in. Well, I would like to have the criteria and the information they have as to how to spot those people. Because in 30 years of experience, I will tell you, you can't do it. It happens in the blink of an eye. Does it happen when my grandchildren are riding their bicycles past that house and someone is unhappy and storms out the door and rants and raves in the roadway? Does it happen to their 2 people, video-trained staff that are there to watch? They monitor, they try to de-escalate. I didn't see anybody talking to the man that was walking up and down the street, saying that nobody knew what happened in there, and they wouldn't give him his belongings, and they wouldn't give his meds. No one came out to de-escalate that. No one came out to engage him. And the people that were in the house don't have the experience, the knowledge, and the training or the education to do that. That's the question I would have you ponder. Come out, live in our neighborhood. Live in our neighborhood. We'll sell you a house. You can live right there and see what happens. Thank you.
Thank you very much. Any questions? Thank you. Thank you. Daryl Jones? Please state your name and address. You have 3 minutes.
Daryl Jones, 10898 West Chapin Avenue. Imagine that an out-of-state corporation bought the home next door, held a neighborhood meeting, and announced they were opening a drug abuse treatment center in the house next door. Imagine your dismay when they tell you that planning and zoning has already approved their conditional use permit, and the meeting was just a courtesy to let the neighborhood know that they plan to operate a business in the house. Imagine over 100 people attending the meeting and only a few being allowed to ask questions, comment, or voice concerns before the meeting is shut down. Imagine finding out that Central District Health denied a permit for the property next door, stating it would be impossible to install an adequate septic system on the property for the business. Imagine finding out that this corporation has misrepresented their business as a residential care facility in their application, but their website states their new facility is a medical facility for treating drug abuse, alcohol abuse, and mental disorders. Imagine preparing to come to a planning and zoning meeting and finding out that it's postponed. Imagine your dismay when this corporation, knowingly in violation of subdivision covenants and without obtaining a conditional use permit, opens their business and starts accepting patients before getting a conditional use permit or health department approval. Imagine this business wants to change this house in a residential neighborhood to a commercial business and install an operating incinerator because the property is too small to accommodate their commercial enterprise. Imagine the effects of this business on your neighborhood, safety, property values, noise, traffic, and potential illegal activities and the loss of quality of life in your neighborhood. This is exactly what Icarus has done. Please stop this national corporation from operating a corporate enterprise in a residential home designed for family living. On a side note, I had people coming to my house daily and stopping at my house looking for this business and asking for directions. I don't know why they had so many people looking for this business. Please vote on this issue as if this out-of-state corporation bought the house next door and was operating next to you. Thank you.
Thank you very much. Any questions? Thank you very much for coming down. Jacqueline Warner? State your name and address, and 3 minutes yours.
Hello, my name is Jacqueline Warner. I live at 11260 West Valley Heights Court. I can see this facility from my backyard. Their second-story window overlooks my property. I would like to note or comment on, they said that it is a 24/7 secure facility. On my way here tonight, their back gate was open, and there was no one available or there to close it or secure the facility. I do have a photo. I just don't know how to get it to you guys because it's on my phone. But their facility was unsecured on the way here tonight at about 4:30, 5:30-ish. And I would just like to note that I oppose this. And I moved there to have a safe, quiet, calm neighborhood, not a medical facility. As someone who receives mental health treatment for PTSD and previous drug issues, these are medical services. There is no way around it. The only way that you can provide these services is if you are a licensed or certified individual in the medical facility. There is no way to get around that. And they have what are called national provider identifiers. Someone who has worked with medical billing, those are used as a facility identification. They are used to mark that it's a medical facility providing medical services so they can bill insurance and private entities for these medical services. That is my time. Thank you.
Thank you very much. Any questions? Thank you for coming down. Connie Bogus? And Gary Bogus, you're next up. Please state your name and address.
My name is Connie Bogus, 11370 West Chapin Avenue. I've been there for 50 years. I've raised my children, grandchildren, and now my great-grandchildren. I have a 4-year-old. My neighbor who's 3 houses down from there is watching a 3-year-old and a 5-year-old, and I'm watching a 4-year-old. And we're within 5 houses of this. It raises a concern for me because I've been in that neighborhood forever, and it's for family and for friends, and I've been by there, the back gate was open. There's school below them, that they look out over the school. There's a school another half mile away. It just doesn't fit. That's all I have to say. Thank you.
Thank you very much for coming. Any questions? Larry Bogus? Thank you. Sherry Turner?
You need to unlock your iPhone first.
My name is Sherry Turner. I live at 11060 West Columbia Road. I'm like directly south of this location. A lot of the things I was going to talk about have been brought up, and I agree totally with them. I want to point out, if you look out here, how many of these people that live in my neighborhood are senior citizens. We are a vulnerable portion of society. Just the idea of what could happen in a home housing 16 individuals, I don't care what their issues are or whether they're totally normal. You stick 16 people and 2 more as referees, you're going to have problems. We're no longer going to have the kind of neighborhood we're accustomed to. I can sit on my patio at night and hear absolutely nothing except for maybe a few bugs, out there. It is that remote, it is that quiet, it is that peaceful. That is why these people live where they live. This is going to impact our community by a lot. I also want to address real quickly this whole house incinerator. I'm not sure that I feel like that is the answer to this property. I don't even know if there's an active whole house incinerator. I'm sorry, I'm getting emotional. Even in any part of the Treasure Valley. I'm not sure. I tried to research that. I couldn't find anything. But what I did find is that that type of a system should be a last resort when nothing else will work, and generally in very remote areas. Like if you go out, say up in the mountains, and you buy a piece of property and they will not let you have a septic system, that may be the alternate. And you're probably going to be using that kind of system on a lowercase basis, not for 16 residents and for 2 staff. Real quickly, I just want to say under IDAPA 58.01.03.007.08, it states that a whole house incinerator should only receive the same amount of daily flow that a standard septic system would. So if they've already been denied usage with the standard septic, why should they be able to get away with using something that is supposed to not receive anything more than what is already there for them?
Thank you very much. Excuse me. Any questions from the commissioners? Thank you very much.
Thank you.
Patrick Stanley or Starkey? Please state your name and address. 3 minutes.
My name is Patrick Starkey, 7435 South Glenridge View Drive in Boise. I simply ask you guys to consider everything you've heard here tonight, right? If you guys were 30, 35 years old and you were raising a couple of young kids, would you want this facility moving in right next door to you, right? Or if you are, you have elderly parents that are still living in the house you grew up in, and this facility moved in right next door to them, what would you do, right? Their lawyer talked about this not being a medical thing. Behavioral health, as a lot of other people have talked about, it's a medical thing, right? He brought up non-medical, medical, physician, right? What's a physician? Somebody who treats not just disease, but also mental disease, right? Psychiatrists are doctors, right? The incinerators, would you want that next to you, right? And the smell of that, regardless of whether it's, for a certain number of people or okayed for a certain number of people. Just think if this was happening to you, what would you want done? And I think if you take that into consideration, you'll make the right decision. Thank you.
Thank you. I have a question for you. Just waiting for just somebody to ask this. So the current facility with up to 8 people in there and 2 staff, what is the effect on the neighborhood right now in its current state?
Well, I think you're still having individuals that are receiving medical treatment who should be somewhere else to receive that treatment, right? I don't think it needs to be in a residential neighborhood. Other people have talked about the language and it's not very secure. So I think you're putting young people and older people at risk of something bad happening. And I understand that it's not, I think a lot of hangup has been on the treatment of drug or alcohol addiction. But I think there are a lot of other mental health disorders that are just as dangerous. And so I think that should be considered.
Well, in its current state, would you say it's had a negative effect upon the neighborhood in its current condition?
I think so.
Thank you very much.
Thank you.
I think it's Newell. No. You live at 10251 West Chapin? Okay. And Bonnie Barkus? State your name and address, please.
My name is Bonnie Barkus. I live at 11150 West Chapin Avenue. I'm directly across the street to the north from this facility, proposed facility. Couple of things that I would like to bring up is I have acreage. I actually own 20 acres across the street from this facility. I run livestock, got a horse. The guy that's renting the old farmhouse has cows, chickens, everything else. We've already had one call about roosters. I'm waiting for him to call and complain about the turkeys that are free range out there. I am concerned about, complaints about noise from animals, flies, smell, whatever. I just don't think that this kind of facility really fits with the area that's out there. And I would hate to see somebody from this facility happen to notice that somebody has come out and is butchering sheep, down by my barn. I am running an agricultural business there. I've kind of downsized some, but I still have 40 head of breeding age ewes. Neighbors got quite a few more. So I would just bring that up as that's a kind of a conflict in my mind between a commercial venture with people that are possibly a little unstable across from an active farm type situation. Plus I have concerns about dogs. That hasn't been brought up, and I'm assuming that they would say that dogs won't be allowed, but that's been one of my biggest problems with the sheep, is dogs. So, unless you've got some questions.
Do you have any questions from the commissioners? Thank you very much for coming down. We've been at this for about 2 hours. There's two things. We're going to just take about a 7-minute break. We'll try to get back here about a quarter after. If you want to speak and you haven't signed up, I'm going to put a list here on this table. Oh, it's over there. There's a list on this table. If you haven't still signed up when we come back, we'll still have make it available for you to come up and speak. And you'll just, as you come up, you'll sign in, and then, or after, actually, you'll speak, and then on your way out, please sign the list. So we'll take about a 6-7 minute break, and we'll be back here. we'll call your name, and again, you have, come and give your name and address, and you'll have 3 minutes. Leanne Burfind?
Good evening. My name is Leanne Burfeint. I live at 6805 South Santa Cruz Drive in Boise, and I love being in Boise. And I have not lived in the neighborhood near as long as most of these other people, but I love my neighborhood. It was been said that the CCNRs are probably not legal or whatever. I just want to read to you what these people had information on when they purchased the property. Under the Sunset Villa subdivision neighborhood CCNRs, number 1 says restriction against business use. That the grantee or grantees under any conveyance shall not at any time conduct or permit to be conducted on the premises to be used by any other purpose whatsoever except for the purpose of a private dwelling and residence, together with the customary outbuildings, garages, etc. Nuisances is number 5. No noxious or offensive activity shall be carried on upon any lot, or shall anything be done thereon which may become an annoyance or a nuisance to the neighborhood. I don't know that those are not enforceable. Maybe they aren't. And as far as it still being in effect, binding effect of restrictions, duration, automatic renewal. The ongoing and protective restriction shall run with the land and shall be binding by all parties and all persons claiming under them for a period of 25 years from 1961. Now we've exceeded that. At which time said protective restrictions shall automatically be renewed for an additional period of 10 years. We're still later than that. On a successive basis, unless, so 10 years and then 10 years, and we got it, right? Unless 75% or more of the owners record at that date, agree in writing to changes, and said changes are made in a lawful manner. Now the incinerative toilet. I have firsthand experience of having to use one of those things. And the guys that I worked with would go to the bathroom outside instead of using it, and it smells atrocious every time you turn it on. Every time. Not once in a while. Every time. And that's all I have to say.
Thank you very much. Any questions? Thank you very much.
You're welcome.
Rebecca Peterson? Please state your name and address, and you'll have 3 minutes.
My name is Rebecca Peterson. I live at 11302 West Valley Heights Court. My concern is, and good evening, is that I have teenagers that get picked up and dropped off 2 doors down from this facility by West Ada school bus at 6:30 in the morning, and they get dropped off in the afternoon at 3:30. With that video you saw of the gentleman screaming outside, whatever, it makes me concerned to the point that I drop my teenager off at the bus stop at 6:30 in the morning every day before I go to work, because it's concerning about what this facility is. You already been told about the elementary school just below. If I'm concerned about my teens, about this facility being in the neighborhood, that is a family neighborhood. And where we're concerned that we have to either watch out for our kids to the point and we can't trust them to walk, ride their skateboards or their bikes, or do anything because of this facility in our neighborhood. Who wants somebody screaming obscenities? I mean, my teenager gets enough of that at school, to be honest. You know, I want them to be safe. I've lived in the area for 30 years. And my concern is Not only the safety, I even asked West Ada to move the bus stop. They refused. It wasn't a good enough reason. So my concern is, what do we do about the elderly, the children, the school, the West Ada stops that are there for our kids that ride the buses? They stand out there for 10 minutes waiting for the bus. And that's my concern, and I'm scared to death with what's going to happen if you get another demonstration of somebody that early in the morning. There are no lights, street lights or nothing along that road at 6:30 in the morning. So my concern is what's going to happen when you have another out-of-control person that wants to leave that facility, screaming on top of their lungs. You know, are they going to come combative or what? How are we supposed to deal with that? That's my concern, and I appreciate your time. Any questions?
Any questions from the commissioners? Thank you very much for coming down.
Thank you.
Steve Henkel? And Beverly Henkel, you'll follow him? Please state your name and address.
My name is Steve Henkel, 11320 Chapin Avenue. I'm an Army veteran, retired, been in this neighborhood 35 years. I have questions in the fact that this house was not a residential home previously. There was not a family living in this home. This was used as a, in my opinion, a purpose-built commercial building. Okay, so there was not a family living there and moved out, and then this permit come up. That's number one. Number two, I don't understand why they picked this location when you can go the end of Cole, Cloverdale. There's rural properties for the same amount of money or even less without all these problems, without all this controversy. One other thing I'd like to bring up with the children walking through the neighborhood, if there is a legal incident, or if there's an incident with these folks at this home, when they leave that home, who's legally responsible for them? Because are they individual citizens at that point? Or are they still under the care of that facility? And who gets sued if they decide to hurt a child or commit a crime? That's all I have. Thank you, sir.
Thank you very much. Any questions, commissioners? Thank you very much for coming down.
Thank you.
Beverly?
Opposed.
Thank you very much. Barbara Sanchez?
Stepped outside a few minutes. She'll be back.
Okay, we'll come back to her then. Brent Colburn?
Opposed.
Thank you. Chad Dickinson or Dixon?
Chad Dickinson, 11411 West Southview Court. I just wanted to connect the dots. Someone actually took my line before I got up here, basically pointing out the fact that there is a school bus that's located probably less than a half a block away from where the incident occurred. And that I really feel like the business has already dodged a bullet by not having a busload of school kids dropped off at the time that this guy was outside having his episode. And that there was no one there to stop whatever could have happened from happening. I want to express my concern that with having that many patients and 2 people to control them, that there's a very high probability that there's going to be instances where they can't control them. There already has been one, so it will occur again. I think that given all of the circumstances of the things that having employees that are not educated and trained, they've just been hired off of the internet, and there's no way to certify their education and keep control of their certification in that facility, and they are issuing drugs to patients regardless of the medical person who's issued them to take these drugs. If they are told that they have to take drugs before they go into the facility, there still has to be a person that's educated to be giving those drugs to those people. And so it's concerning that there's going to be an uneducated person, unqualified person giving drugs to a person in this facility. My other concern would be that I think, just to go back around to the fact of the incinerator with the air quality, if there's a stint, we know that there's been times where the air quality has been bad for 2 or 3 months in this area. So with 3 months of them not being able to run their incinerator, it gives you all the probable cause to not allow them the conditional use permit. That's all.
Thank you very much. Any questions? Okay. Barbara Sanchez. Please state your name and address.
Barbara J. Sanchez, 7224 South Hilltop Way, 83709. I'm opposed with my whole heart and soul. I've been up my hill. I built the home 50 years ago. Our kids walk down those very streets to get to that elementary. Now my neighborhood is full of elderly and young children. I have about 4 families of young children who need to go to elementary. We were too far for the buses. My kids had to walk. I'm here to advocate for them. I cannot believe we are still here. This is totally ridiculous. I feel scammed. I bought a residential lot in the middle of nowhere. There were no houses around me. If it was for businesses, then it should have been zoned for businesses. And you asked, have they impacted the neighborhood yet? Well, you've heard they've left gates open. You've heard one person himself wandering around. Well, what the hell? It only takes one person. I don't care if it's in 1 month, 2 months, 6 months. All it takes is one person. And I'd like you to put yourselves in that position. Your grandchildren, your grandchildren. All of you. It doesn't look like you're too young enough to have children, but it is ridiculous. Why are we here? Why? It should be solved. Should never have been an issue. And you've got plenty of statements that show that you don't have to decide for the Fair Housing Act. Good God, let's end this. This is ridiculous. It's been going on for months and months and months. And where are the people monitoring the people that are in there without permits? I've had it. I mean, I'm all for common sense. I just can't see an ounce of it going on here.
Thank you very much. Any questions?
Any questions?
What a way to wrap it up. Okay, no, okay, sorry, not quite. Yeah, if there's anybody else who didn't sign up who'd like to come forward, please, right now is the time. Okay. Yeah, how about go ahead and talk and we'll give you 3 minutes, and then on your way out, just write your name in on that.
My name is Amber D. Maria. I live at 11522 West Southview Court. Thank you for hearing us out tonight. One thing I wanted to bring up, 2 points, is I moved in 10 years ago. My children were in diapers. On my street, I have at least 9 kids, and I've watched all those babies grow up. My kids are now 11 and 12, and all of those kids next door to me, they are all approaching those teen years. Where they used to just play on our street and in front of our homes, they are now walking the streets. They want to go on walks with their friends. One of those places that they go to is the elementary school right near this property. And we've had to change, it's already affected us. We've already had to change our behavior and tell our kids they can't go down Chapin. It's not safe. We don't feel comfortable. And it's really hard to say that to young kids. And it's also another thing of, they're so young that we don't want to put a cell phone in their hands yet. We want to keep them pure and tech-free, but now these things like this pop up and we're thinking, well, gosh, do we have to put a cell phone in their hand just so we know they can be reached or they can get a hold of us? So that's the child perspective, but I'm the popsicle mom. I could easily list off 20 names of children in our neighborhood that I've watched grow up, and I'm worried about all of them. I'm also heartbroken at looking at all of our senior citizen neighbors. They shouldn't be worried about this. They shouldn't be here at 9 o'clock at night. They want to live in peace. They want to die in peace. They want to be safe in their homes. None of these people feel safe. It's really sad, and it's up to us to speak up for them and help them through this. So that's why I'm here tonight. The last point I wanted to make is my friends have a ranch in Horseshoe Bend, and they have an incinerator toilet. And I was there about a month and a half ago, and I used it myself. And that was a very interesting experience, because the way you use one of those devices is you have to line the toilet with basically like a giant coffee filter. And you do your business, and then you press a button and it goes away and it burns. And you hear it and you smell it, and it takes about probably 3 to 5 minutes for it to go through that cycle. So as I think about this facility and 16 plus people using those types of toilets, and I believe I heard 4, imagine detoxing from drugs or being sick with GI issues, and you're running to the bathroom to vomit or other things. And you have to stop and pause and make sure there's a liner in that toilet. It just doesn't sound like it's a working solution for that quantity of people and that aspect of medical use. I just don't see how that's a feasible solution. So that's all. Thank you.
Thank you. I have one question. So the toilet that you use, is it the kind where the incineration actually takes place right below the seat or just right next to the toilet?
I believe it was below, so the waste drops down, and then it's like right there in the area. Yeah.
All right, thank you very much. Is there anyone else who would like to come forward? Okay, thank you. So at this time, we go back to Mr. Danielson. If you have any questions for staff. Commissioner Rowley?
Yeah, Mr. Danielson, regarding the incinerator septic system, my understanding is this is more an industrial outside incinerator system in a vault and not something at point of use. Is that correct?
Mr. Chairman, Commissioner Rowley, that is my understanding as well. And the applicant's engineer, Joe Canning, is here, and Joe could probably provide a little bit more detail on that, how that system would work.
Yeah, a lot of people express concern about kind of these point of use incinerators. I think we're missing the mark on what this
Yeah, it's my understanding. I think it goes into a septic tank
outside,
and then it gets, I think, pumped to one of 4 incinerators, and then it gets burnt up there.
Yeah.
Any other questions for staff? If not,
Mr. Chairman, before we go, I would like to enter the presentations into the record.
And these are the letters?
Yes.
Okay.
So exhibit number 100 will be my presentation. Exhibit number 101 will be Jeff Bauer's presentation. Exhibit number 102 will be Jenny Stoy's video that she presented. Exhibit number 103 will be Will Stoy's presentation. Exhibit number 104 will be Vonda Witsitz's written testimony. Exhibit number 105 will be Erica Bermasola's letter. Exhibit number 106 will be Casey Bermasola's letter. And exhibit number 107 will be Betty Bermasola's letter.
Thank you. I did have one question, Mr. Danielson. Just so this is a conditional use permit. This is not something that comes up for review in 3 or 5 years. This is once it's.
Mr. Chairman, this type of conditional use application is in perpetuity. So once it's granted, it's as long as they comply with the conditions of approval, this use would remain in perpetuity.
Right. All right. Thank you. We'd like to invite the applicant back up for rebuttal, and you'll have 5 minutes. And we'll give you some extra time. I know there's a lot of comments to address. So,
thank you, Mr. Chairman. I'll do my best to be brief. Jeff Bauer, 601 West Bannock. First, I'm going to take up a few corrections or maybe misstatements in my original testimony. So, first, in terms of training of staff are certified in CPR, crisis intervention, de-escalation, and food handling. Staff does not administer meds, but they provide medications, and I'm told this is a technical term, observe self-administration. We will not leave residents that do choose to leave the facility out on their own. I think that was an impression that a lot of the public that we've heard have seem to have. If people choose to leave this facility and our de-escalation techniques don't work and they don't come back, while we're in contact with them, we will call law enforcement. I mean, that is the procedure that we have outlined. I want to talk quickly about consistency. There's a lot of testimony tonight that we're moving the ball or that this is a constantly changing application. That's not the case. From the jump, from the time we met with staff, had our pre-app, we called this a residential care facility. The public meeting notices we sent, residential care facility, our application was consistent, and our testimony tonight has always been consistent. A lot of the testimony, again, in writing and tonight, is trying to place the information on our website to only this one facility. And I want to reiterate that we have multiple facilities in the Boise area that provide multiple services, including inpatient detoxification services that happen elsewhere. It may be vague on our website about where those services are provided, but that's intentional. In this industry, you don't want people to know where HIPAA-protected residents are living. You don't want their family to be able to, come find them or their friends and things like that. There's privacy concerns as to why the website is organized the way it is. The use. There's a lot of discussion tonight, too, about this isn't allowed. It's a commercial use. I think staff did a really good job clarifying that, but I want to do it again. As a matter of right, in the R6 zone, you can have 8 residents, 2 staff. And the use that we've asked for tonight, a residential care facility, is also allowed in the R6 zone with a conditional use permit. So again, the county has made the legislative decision that the use we're proposing is allowed in that district subject to conditions. We've offered up some sideboards to condition this project, number of residents, staff, monitoring, et cetera. We've gone through them all, but if there are more questions about those, I'm happy to address them. Mr. Canning is here from Centurion, and he is certainly way more qualified to talk about the septic system than I am. But Commissioner Rowley, your understanding is correct. The bathrooms in this home will function exactly like the bathrooms in any municipal home would function. You'll flush the toilet, it'll go into a tank, and from that tank, the waste is pumped to underground incinerators. Mr. Canning assures me that there's no air quality issues and that these facilities are permitted by Ada County, DEQ, and Central District Health. Central District Health does not have any jurisdiction over our zoning. There is a comment letter about, kind of who goes first in this instance, and this is standard. They don't approve a permit for a use before it's approved. So you guys are the horse, they're the cart. We need the CUP before they look at our permit for the incinerator system. We have shown, and I believe staff agrees, your staff report, that the current use is allowed. We are asking for the CUP to treat more people in need. And I think that's important in this context, and especially in Ada County, where the health department has declared that it's a mental health provider shortage. So these facilities are in tremendous need in this community. The licensing agency, Magellan, and the Joint Commission, they are very supportive of this facility and have been very helpful. We do meet the CUP approval criteria. Again, happy to walk through those if you would like, but I think it's well written and well presented by staff. But in addition to meeting those criteria, we have asked for a reasonable accommodation under the Fair Housing Act. And failure to grant a reasonable accommodation is discrimination. Approving this CUP, we believe, is inherently reasonable, and I'll just touch on the reasons real quick. Again, the use is allowed in the R6 zone. The home has capacity to provide the behavioral health services we are offering. And 3, all agencies reviewing the application have no concerns. So there was lots of testimony tonight, and I think Commissioner Birch, your line of questioning for 4 or 5 folks was indicative. It's right. What if this was something different? Would you still have a problem? And the answers we heard were consistently yes. This is a good use, but the wrong place. It doesn't fit in our neighborhood. It's our neighborhood. It's not their right.
Go ahead, we'll give you a couple more minutes. Yeah, go ahead.
Every neighborhood in our community has kids, elderly folks, schools, bus stops. That's the nature of neighborhoods. And that's why the Fair Housing Act exists, is so that people can get care in that environment that is healing. And so we, again, would ask for your approval. We do feel like we meet all the criteria and the fair housing criteria. Just real quick, touch on the conditions. So I already mentioned the limitation on residents. Again, happy to reread it. But in addition, there are a couple things came up. Fencing on the south boundary. Frankly, that was news to us, just given the density of the trees. It was, but we're happy to build a 6-foot privacy fence on that boundary line if the commission would like. And we're also, I think, Chairman Wickstrom, your comments about you could have more staff. We could. And we're willing to do that. So if the CUP is approved, we're willing to add more staff.
Any other?
That's it.
Okay.
Yeah.
Any
Thank you.
questions for Mr. Bauer? Commissioner Colson.
Thank you, Chairman.
Just for you, ladies and gentlemen, you have conducted yourselves very well tonight, and I really appreciate it. Please continue to do that.
Got a quick question. So right now, R6, you guys, and this may be a question not only for staff, but might be a question for Central District Health. As of right now, with you having 8 residents in there, or people, and 2, is the septic system that's in there now adequate?
Chairman Wickstrom, Commissioner Colson, we believe the answer is yes.
Ma'am,
Please,
please.
And I'm happy to have Mr. Canning come address that. I know a lot of the residents have had conversations with Central District Health about our property, and I'm not privy to those. But part of this process, and you saw it in the exhibit, slide 7.
No, I'm familiar with Central District Health and everything else like that. I mean, if Joe Cannon can speak on that, or
Yeah,
staff.
I'll let Joe
And
come
staff may be able to, I was just curious if what your answer was.
I'll let Joe come speak to it, but in this process, right, Central District Health has regulations. They have a table of uses, and those uses have, a number associated with flow.
Sure.
None of the uses really fit us perfectly, and so that's why we did work with them to provide flow rates from other facilities, and we eventually landed on what we thought was a fair number for flow. And the current system does support the allowed by right use.
Okay, thank you.
Any other questions? Commissioner Birch.
This may have already been addressed, and so if it has, I apologize. When the property was purchased, it was just dirt, is that correct? And then this facility was built on it?
Chairman Wickstrom, Commissioner Birch, no, sir. The seller was a man named Cameron Brown. I don't know how, I don't think he owned the property long, but we found the property just on an MLS listing with the home completed as you see it today.
So it was listed on MLS as a residential facility?
Yes, sir.
Okay. And it was purchased when?
The deed's in the record, but I want to say April.
Okay, April.
2025.
And then in May, you started operating. And there is a permit in place right now for this facility to operate as it is?
Chairman Wickstrom, Commissioner Birch, no permit is required.
Under federal law?
And Ada County zoning ordinance.
Okay, so what is required is the approval of the governmental body for the expansion. That's why you're here tonight.
Chairman Wickstrom, Commissioner Birch, yes, sir. To exceed 8 residents, we do need a conditional use permit.
Okay, thank you.
Any other questions? I have one, going, this incinerator is something else here. Central District Health just kind of gives you a preliminary, that sounds good, or is it, there's a mention here that the engineer, who's the engineer represent, that's him.
I'm going to bring him up. We keep talking about him. Let's bring Joe up.
What? Now, the reason I was asking is that, is it, at what point, what kind of a commitment, or, I know commitment's not the right word, but just a preliminary indication that this type of system would be acceptable? What is the feedback that you've received from Central District Health?
Yeah, my name's Joe Canning. I'm employed by Centurion Engineers. The address is 2323 South Vista Avenue at Suite 206. And yeah, we worked quite a bit with Central District Health Department on this application. And I think it might be good to let you know that the real issue is not incinerator, not incinerator. The real issue is this property is in a nitrate priority area. And that's the issue that we're having to deal with. The property size is not really adequate to handle additional nitrate discharge into the aquifer in the area. So DEQ has the option of using incinerator systems to eliminate that because there is no discharge. So what we've worked out with Central District Health Department so far is that is the intended solution, is multiple uses of incinerator systems, whole home incinerator systems. And we just need to get the CUP approved so that we can submit to Central District to actually get the construction plans approved for that system.
Okay, so otherwise, there's really been no indication from them one way or the other. That's your recommendation for them to bring that after?
Well, no, we did receive comments back from Lori at Central District Health Department that said that the incinerator systems is the way to go with the property.
Okay, great. Thank you very much. I appreciate you coming up.
Sure.
It's sitting for so long. It was informative.
If I could just add to that too, Chairman Wickstrom. So I got the slide up here. So it's, if the property obtains county approval, the engineer has suggested an incinerator system, which is a non-discharging system approved by DEQ, this would be allowed. So, that is DEQ saying, Central District Health saying that the system we propose would be allowed.
Okay.
And I also want to add that planning staff has included a condition of approval that we can't exceed that 8 threshold until we have an approved, built, and inspected system.
Very good. Any other questions? Yes. Commissioner Rowley?
Yeah, regarding a kind of a follow-up to Mr. Birch's question, if the application for the conditional use is denied, would it be the applicant's intent to continue to operate at the facility at the 8-person or less limit?
Chairman Wickstrom, Commissioner Rowley, I think that is the case, but I can't say for sure. These facilities are expensive to run, and you need a certain amount of occupancy to provide the services to people. And so, if not granted and we're below that threshold, I can't say for sure what will happen.
Thank you.
Mr. Chair.
Commissioner Murphy.
Hello, Mr. Bauer. Just thinking about this reasonable accommodations, wouldn't a better definition of a reasonable accommodation would be maybe in buildings with a no pet rule, that maybe that rule might be waived for a person with a visual impairment who uses a service dog or other service animal, and not doubling the capacity of a particular substance abuse or residential care facility. I think it's schizophrenic, the definition of what's going on here, quite frankly. But that would be a reasonable accommodation. Doubling the occupancy, I think, is above and beyond that definition. What do you say?
Chairman Wickstrom, Commissioner Murphy, great question. So we aren't doubling the occupancy. Ada County has no occupancy threshold for residential care facilities. The Fair Housing Act, has been applied in circumstances like this in hundreds of cases across the nation of sober living communities, residential care facilities, where reasonable accommodations are made for a specific number of people or to allow a residential use where it typically isn't allowed, say in a commercial zone. So this is a very common use. It's a very low level use, I would actually say, because again, the use is conditionally allowed. For instance, there is one case from Idaho that's sort of informative, went to the Ninth Circuit Court of Appeals called Turning Point v. City of Caldwell. In that case, I think it was a homeless shelter, and I want to say there was 28 people in a 3,000 square foot house. And the court upheld it and said that Caldwell's limitation on the number of people was unreasonable, and they needed to make an accommodation.
Thank you. Yes, certain courts definitely respond certain ways in certain jurisdictions, as we all know. But just looking at this, because the federal FHA, it also gives local jurisdictions the ability to make a decision based upon health, safety of the individuals and the neighborhood. It also allows for that. So that's also in that law. But anyway, thank you.
Thank you. Any other questions?
Chairman Wickstrom, just a chance to respond to that?
Yeah, sure.
Okay, so I'm not aware of anything in the Fair Housing Act that speaks to third-party perceptions. It does allow local zoning ordinances to provide thresholds on the number of people, and those are common. You'll see some jurisdictions say, 5 people per 1,000 square feet. I've seen that in other jurisdictions. Ada County doesn't have that, so you have no specifically enumerated standard, and that is in the Act. It says, nothing in this subchapter limits the applicability of any reasonable local, state, or federal restrictions regarding the maximum number of occupants. And so again, that is what it says. Ada County doesn't have such an ordinance, and you'd still have to apply it reasonably. So where we have fire saying it's safe, no comments from any agency saying it's unsafe, it would be unreasonable to deny.
I think I'm looking at, just for your reference, 3604, Section 9 is what I'm specifically looking at.
Okay, yeah, no, so I'll read it. Nothing in this subsection, and that subsection is you cannot discriminate. Nothing in this subsection requires that a dwelling be made available to an individual whose tenancy would constitute a direct threat to the health or safety of other individuals whose tenancy would result in substantial physical damage to the property of others. So I think my read of that, right, is other tenants in that facility. So internal to the housing that's being provided.
And then the gentleman who was outside, do you know, on the video, do you know what that was in regards to? Just to give you an option to talk about that.
Sure. Yeah. So the gentleman, I mean, you saw the video. He was distressed. Again, these people do have behavioral health issues. But yeah, I mostly saw a guy standing in the driveway yelling, nonviolent, not moving. But his issue, as I understand it and speaking with the client, is that he wanted his belongings, and those were belongings that were left at the admin office because they weren't needed at the house. Getting back to the issue too of not in my neighborhood, good use, not here. Filming private property is trespass in Idaho. And the Federal Housing Act specifically has this language that says, it shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise and enjoyment of providing fair housing. or any other person in the exercise of any right granted or protection. So, I mean, you know, harassing and bothering people doesn't create a neighborhood. And I'm not saying that's what they're doing, but, you know, this is going to be part of the community. And I think, you know, standing outside and videotaping people and writing down license plates and looking over the fence, you know, that doesn't make them feel comfortable either. And so my response is that, yeah, I mean, it happened, and I think it probably will happen again. I live in a neighborhood where hundreds of people walk by every day. I live, you know, downtown Boise, and people scream and shout. And, you know, one day there was a lady in my yard with her pants off, just walking by. Stuff happens, and we can't prevent everything.
Mr. Chair, if I might just have a couple follow-ups real quick.
Good, go ahead, just briefly.
You had mentioned your trained staff has crisis intervention training. What does that mean?
Crisis intervention training, I believe, deals with precisely that, right? You are trained to respond to situations that would, in this case, be, you know, contacting providers, contacting emergency responders, anything to, I guess, address whatever crisis is presenting itself.
So they're trained to call the, I guess, fire or police or police. Is that right? Or do they have more immediate training, I guess is what I'm asking.
Commissioner Wickstrom, I guess I'm not fully understanding the question, but yes, they are trained to call the police and or fire or whoever first responder would be needed in the event they're unable to control the situation.
Okay, thank you.
Yeah.
Any others? Commissioner Birch?
It was mentioned that there was an individual besides the one that ended up being hauled off that Commissioner Murphy is talking about that just walked away. I gather from what you have said, he was not allowed to come back to the facility since he left. Is that correct?
Chairman Wickstrom, Commissioner Birch, it's my understanding that both facilities were the same individual. And on the second intervention from law enforcement, he did elect to leave, and he left with law enforcement.
Okay, so if it was the same individual, how did it happen that he was back there again?
He did, Chairman Wickstrom, Commissioner Birch, he didn't leave I mean, you saw where he was. So, you know, I believe the facility saw him, staff saw him at all times. And you know, he was not out of sight. So
No,
he didn't
but
leave.
there was discussion of somebody that had actually walked down the street that people saw. And if that's the same guy?
I believe that's the video, sir.
I'm seeing a head shaking no that it wasn't the same guy.
Chairman Wickstrom, Commissioner Birch, according to my client who I asked at the break, you know, what the two law enforcement incidents were, it was the same individual.
Chairman, can the applicant themselves actually answer the question? That was who was shaking their head no.
Mallory.
Just go, yeah, please.
And
Thank you.
please give your name.
Yeah, please give your name and address and.
Name and address.
Mallory Harris, 901 North 27th Street, Boise, Idaho. Okay, so I was actually shaking my head no because no one's ever physically walked off the property and not returned in any capacity. I wasn't sure where that information was coming from. This gentleman did, however, step outside in the front area, two separate.
Okay, so there was nobody that actually had walked off ever. Okay, all right, good. Thank you for the clarification.
Thank you.
Thank you. But isn't it that the clients there are supposed to not be in the front yard? They're supposed to remain in the backyard at most, or inside the house, inside the property. So
Chairman
just by
Wickstrom,
going into the front yard.
those are the conditions we're proposing right now with this permit.
Okay.
It's not required today. I mean, that's our policy, but
Thank you. It's a policy, but okay.
yeah.
They're not part of the condition. Thank you. Commissioner Raleigh.
Sorry, one final question. Why did the applicant choose this neighborhood, this home, for this business? Why there? Just wondering.
Chairman Wickstrom, Commissioner Rowley, I think it's a variety of factors. I can speak to a couple. I can't say for sure, but price point. I think it's a very nice home, provides a very nice facility for people in need. The location, it is close to the city limits, and a population center that needs treatment. Ultimately, right, you want to locate these things near people that need it. I think that's one of the biggest draws. And then again, the size of the house, the size of the lot, I think lends itself well to the use.
Thank you.
Any others? I had a couple questions. So do you accommodate people who have support animals?
Yes, sir.
So somebody can bring a support animal on a facility with them?
Yeah.
Okay.
Subject to, right, any landlord that has, we're subject to the Fair Housing Act just like any other landlord would be. If someone legitimately has an animal and they're safe, yes.
Okay. And this might be a little touchy, but your staff, how many are women, how many are men currently? Just ballpark would be fine. 50-50?
50-50.
Okay. And the reason I ask is just that some women are not going to be big enough to handle a confrontation with some of these people. And just somebody that's there that can diffuse a situation. So I was just curious about that. And so apparently there's an open gate. Are there locks on the gates on the side yards? Yeah. Okay.
Commissioner Wickstrom, just latches. Happy to install locks. Again, we're open to conditions. Yeah.
Okay. And this has been discussed more or less, but so inside the facility, everything seemed to be in-house, on-site treatments are being done. It's nothing off-site. And in the report that I read, and everything was on-site, on-site, on-site. Nothing going
Great
on.
question. Thank you, Chairman Wickstrom. I meant to address that. There was a comment, I think, in both written comments and tonight that, there might be busing of people here to the facility for the day. That doesn't happen. Their residents or not, there's no daily treatment. And yes, everything is provided to the residents on site.
Okay, thank you very much. Any other questions? Thank you very much, Mr. Bauer.
Thank you all. Appreciate your time.
At this point, we'll look for a motion to either approve, deny, or table to the commissioners.
Mr. Chairman.
Commissioner Rowley?
I would move, certainly subject to more discussion, I would move to deny applicant 2025-00455-CU-MSP.
Actually, just you make your motion. We'll see if we can get a second.
I'll second.
Commissioner Birch seconded. Commissioner Rowley, would you like to speak to your motion?
Yeah, just there's dozens and dozens of people and reasons requesting denial of the application, nearly all of which have a lot of merit in my mind. Noise, nearby school, bus stop location, potential conflict with CCRs, et cetera, et cetera. The only argument that I really heard in favor of it was that it's allowed. It's allowed in that R6 zoning by the county, and they're currently operating without any required permit or other required paperwork, if you will. And they're simply asking to double in size. And I certainly understand that. I understand it's allowed. But I think the argument that that the public has made is certainly stronger in my mind, and I can sympathize with them for a lot of things they brought up, and hence my recommendation.
Commissioner Birch, would you like to speak to your motion?
Sure. I agree with Commissioner Rowley. It is also well established under Idaho law that a conditional use permit is not a right, but it's a privilege, and it should never be assumed that it will be granted. In fact, the opposite is true. An individual should never buy property on the basis of an assumption that the government will grant a conditional use permit. If the applicant could do this by right, you folks wouldn't be here today. The reason you're here today is because the applicant has to come before us to get the conditional use permit in compliance with the Ada County Code. And with that, if we grant it, then you folks would still have the right to appeal the decision to the Board of County Commissioners. Now, we knew when we saw the number of people here that one way or the other, this is going to get appealed to the Board of County Commissioners. The applicant's going to do it if we deny it. You're going to do it if we approve it. And so the Board of County Commissioners, being the elected body, is the one that's going to be making the decision. The applicant has the burden of proof that the proposed use for this conditional use permit meets the provisions of the Ada County Code. And I want to address a couple of those provisions. One of those provisions, and well, both of them actually, are in section 8-5B-5 of the code. And I'm going to read from the staff report, and this is what the code provides. It says, the proposed use shall not be detrimental to the public health, safety, or welfare. The staff has concluded, and they say they find that the residential care facility is not detrimental to the public health, safety, and welfare because it's in conformance with the Pacific use standards for a residential care facility. That is a subjective judgment. It is not an objective judgment. We have very smart staff. They work very hard. But when they make a determination like that, it comes before us, just as it's going to come before the Board of County Commissioners. And from the testimony tonight, it is pretty clear that this would be detrimental to public health, safety, and welfare. And there's already been the example of the cursing going on that people hear, the disruption to the neighborhood. There's many instances, and the people here that are in attendance have given a number of examples. The second part of the code, of the section 8-5B-5, is the proposed use shall not create undue adverse impacts on surrounding properties. Again, staff said, no, it wouldn't. But again, it is a subjective judgment. And in my view, it absolutely creates undue adverse impacts on surrounding properties for the reasons that you folks have given. And so the other point that I think I would like to make is, even assuming that we had 100% complete trust in the applicant, that they would do all the things that they say they're going to do, we don't know that the applicant won't sell that property a month from now, a year from now, 5 years from now. I think that counsel for the applicant, Mr. Bowers, has accurately stated that this property could be used for any of those uses. It could be used for alcohol and drug rehab. It could be used for gender misidentification. It could be used for anything that you people would not want in your neighborhood because it would adversely impact you. And so those two code provisions, without going through the rest of them, Just those two code provisions, in my mind, are justification for denying the application. We aren't saying this is a bad use. It isn't. It's a good use. It's productive. Society needs these. But as the public has said, not here, not in the middle of a residential neighborhood where it does adversely impact these people. And so on that basis, I have to vote against it.
Thank you, Commissioner Birch. Any other comments from Commissioner Colson?
And I would, for me, my hat is off to the applicant for going after, for helping these people, you know, that type of stuff. But again, I look at this as, you know, I agree with Commissioner Birch and our other Commissioner Raleigh. It's, to me, I look at it as you guys knew exactly what you were buying. You knew what you were capable of having with Ada County Code and the 8, and you automatically did that, and you purchased the property to do that. And a CUP is a privilege, and it is a right. And, you know, if it was something that you were living there and you decided to open up your home and that type of thing, and you've owned it for 30, 40 years or whatever, I find that that might be a different avenue. But where it is something that you're going out there and buying, and don't get me wrong, it's needed and people do need help. But at the end of the day, it's, I can't get behind it. And I'm a guy with huge property rights. I'm a guy that if you own the property, you should be able to do whatever you want with it. But at the end of the day, this outreach by the public is huge. So that's all I got.
Thank you, Commissioner Colson. Commissioner Murphy, no comments? Just a quick comment, I guess I wanted to refer to the, I'm sorry? Okay. I referred to just the Ada County Code. Just when I think of a residential care facility, I think of some people who have disabilities who are highly functioning. You know, they may have blindness, Down syndrome, some level of mental retardation. They may hold a job. They're staying there at night and they're leaving to go to work, go to school, whatever they're capable of doing. And under the code, again, there are 5 things: living, sleeping, eating, cooking, sanitation, those 5 things. Yet in this facility, to call it a residential care, it's nowhere mentioned in here about providing any medical services. In a residential care, I again envision if somebody needs something, a doctor visit, dentist, whatever it might be, psychiatric care, it's done off-site in another facility. They're driven there, whatever it takes. It's all taken care of. And this is to make an accommodation for a couple of people who have a more severe problem. Yeah, that's an accommodation. To say we're going to accommodate everybody in this facility and make an exception for them, it's going too far in my view. It becomes a care, not a residential care, but a mental health care facility, something of a higher degree of service to the people who are living there. And I too will join in voting against the application. With that, any other comments? We'll take a vote. Those in favor of, sorry?
Mr. Chairman? Yes. Just a point of order, just to.
Table.
Oh, okay, yes, we're gonna. Okay, so Commissioner Riley, because we're going to go against staff recommendation, we'll need to, and please listen to all of this, we'll need to table it so that the findings of fact can be changed from an approval to a denial. So in your motion, just to table the issue, table the application to the November 13th meeting.
And there'll be no public testimony. There'll be no public testimony,
Right.
just for these guys.
Yeah, there'll be no, it's just a matter of a formality. Yeah, the record will be closed. So just restate, and but you're going to ask for, you're going to table
Okay,
your motion.
Mr. Chairman, I move to table file number 2025-00455-CU-MSP. You need anything further than that?
For a change in finding of facts.
pending a changing in the finding of facts from staff.
And I second.
We have a motion and a second. All in favor, please indicate with aye. Aye. Any opposed? It's unanimous. We thank you very much for your patience and your good conduct tonight, and we're done. Oh,
So, just to be clear, what just happened here? There was an original vote to deny, and now you have
it has to be.
that to be tabled.
Well, it's been denied, but it's being tabled because staff has to change their paperwork to indicate that we as a commission denied it, because they had recommended approval, but we're going to deny it, so they have to change the paperwork to reflect our decision. It will come back to us as a formality, and we'll approve the changes to the finding of fact from staff.
When you come back finally, is that another public meeting, or is that just something for you guys to
It's
sign
just,
off on?
it's that quick. It's a formality.
Thank you.
Thank you for asking. Everybody else thanks you for asking that question.